Yes.
And pardon me, Lord, the WBCRL, Lord, the victims now is missed since that is about 1 year. It has not been recovered till now.
Give it.
Respect Lordship direction.
Please. Please use the mic.
Tired of matter.
Tired of matter? Why are you mentioning now? All right, it's all right. Okay.
Item number 285. PRLA 704.
That's the single bench matter.
Yes, yes, yes.
Don't make mention now.
Let's WBCRL.
Give it.
Present.
Weekly list item number 1.
Item 1, Lordship, is infructuous.
Are you filing any memo?
No, I have not filed any memo.
Please file the memo. Give it.
I am not withdrawing, but my disposal of infructuous. In 2008, I filed this application for production of the minor son.
The
Minor son was missing.
Land Counsel for the petitioner submits that the matter has become infructuous. In view of submission, WPCRL stands disposed of as infructuous. Yes, madam.
19 वर्ष कौन है माइनर सर
This is 2008.
All right, next time.
2008
नहीं 2008 रे 19
Okay.
Item 2.
Item 2 may please, Lordship.
Item 3.
May I plead your Lordship? Here the petitioner is the brother of the petitioner's brother has been taken up by the OP number 5 without intimating from the house on 17/3/2022, Your Lordship. He was working in army, Your Lordship. They have taken the OP number 5 left him from his house on 17/3/2022. All the family members went to the police station. They didn't allow him to meet his brother. On the next day, Your Lordship, when he went to the police station, they were intimated that we have handed them to the army authority and he was taken to New Delhi, Your Lordship. And for about 1 month, Your Lordship, we didn't get any information where our brother was, Your Lordship. On 18/4, Your Lordship, about on para 4, Your Lordship, of my petition, on 18/4/2022, Your Lordship, we received a phone call where my brother said, I'm in a place, I'm not known to me. And that was the conversation, Your Lordship. In the meantime, Your Lordship, for about 1 month, the petitioner's brother, the present petitioner, he approached to all the authorities, Your Lordship. And I have given representation to all the authorities. That is, reflects from page 13 of my petition, Your Lordship. I have given to SDPO, IAC, ASCA, DG Police, SP Ganjam. I have intimated all the members, Your Lordship. After filing this writ application, Your Lordship, when notice was issued, the state come up with a counter that being intimated by the army authority, we apprehended the petitioner's brother from his house and on the same day, we handed him over to the army authority, Your Lordship. After that, I came to know my brother is within the army custody, Your Lordship. Here, my prayer, Your Lordship, while
Army custody
apprehending,
for what? Why?
What
Here my-
offense he has committed?
Offense.
there is one proceeding is pending against him in the army, Your Lordship.
There's an affidavit by the colonel, open number 6. He has.
And being directed by this court, Your Lordship.
13/2/2023.
Just a second. Being directed by this honorable court, Your Lordship, I implemented the army as OP number 6, Your Lordship. Notice was issued and they have appeared and they have filed a counter, Your Lordship.
What is the counter? What they have stated in the counter affidavit? Page number 14. Click करंतु. Okay. What you have stated, the opposite party number 5, it is
My lord, 5, we have filed a subsequent affidavit, my lords, on 24/3/23. On 24/3/2023, we have filed on behalf of 125. It has been filed by the IIC Aska police station, my lord.
one Prashant Kumar Sahu
Yes, ma'am.
has filed.
They filed two counter,
No,
Your Lordship.
initially we had filed one, but this is the
Initially,
latest one.
initial
Now, what
counter.
is the latest one, please?
Your lordship will see para 4.
Para 4. Okay, please read it out.
That it is humbly submitted that the brother of the petitioner, Sri Pratap Chandra Sester, belongs to village Bodakhard of Ganjam district, which comes
You are
under
reading which para?
para 4, my lords, of the affidavit by Prasanta Kumar Sahu,
That is
OP number.
no, that is PSA that date is
Latest.
affidavit filed on behalf of opposite party number 125. Okay, yes, right. Second, come to the second page.
Yes.
Paragraph number 4 you are reading.
4.
Please
Proceed.
It is submitted that said Pratap Chandra Shrestha was working as Havildar operator due to his involvement in the disciplinary proceeding. Captain officiating adjutant for commanding officer who had annexures A by 5 and D by 5 requested the superintendent of police Ganjam and the district magistrate Ganjam to initiate requisite measures at the earliest to apprehend Sri Pratap Chandra Shrestha for completion of pending disciplinary proceeding under section 123 of the Army Act. Thereafter, the IIC Kabir Sujanagar, being instructed by the ADM Ganjam via memo number 431 dated 18/2/2022 to apprehend Sri Pratap and to ensure his appearance before the Colonel Commanding Officer 109 LDR, proceeded to apprehend Sri Pratap Chandra Shrestha. So, my lord, this is the background. He was not reporting to his commanding officer.
But for departmental proceeding, you need custody.
Disciplinary proceeding because he was not reporting. He was not reporting. He had retired in the meantime.
The Army Act टिके देखिए कौन सा?
104 of the Army Act, my lord.
Just
Says.
let us see that.
Let us see that.
Have you got the one?
Army.
Only? हाँ,
Yes.
ठीक. These two provisions are important. One is that 104, the other is 123. So, where 123 says that where an offense under this act been committed by a person while subject to this act and he has ceased to be so subject, he may be taken into and kept in military custody and tried and punished for such offense as if he continued to be so subject. No such person shall be tried unless the trial commences within so and so. And then 104 says that whenever any person subject to this act who is accused of any offense under this act is within the jurisdiction of any magistrate or police officer, such magistrate or police officer shall aid in the apprehension of so and so. So, some proceeding was initiated against the
If
brother.
your lordship will see the affidavit of the commanding officer,
Ah.
it will make things clearer.
That is
13/2/2023.
that is opposite party number 6.
6.
Okay.
The charge is
Para 2 and para 3.
Para 2.
Para 2, next page, my lord, page 2. The charge is that maintaining,
Para 2 টা পড়ুন আদি।
my lord, it is humbly submitted here that number such and such Havildar Pratap Kumar Shrestha 109 Light Air Defense Regiment was arrested due to non-compliance of order to surrender himself for implementation of order of inquiry, in which the above mentioned person was found to be guilty of for the offence on 26/7/2020. The charge is, my lord, I first maintaining an illicit relationship with Mr. X wife,
Mr. X,
Mrs.
Mrs.
X.
X,
Mrs. X, Mrs. X wife of
so and so.
so and so, integrated headquarter of Ministry Defense Transport Company. Second, my lord, association of Mr.
Association with MS.
Association engaged in an activities involving financial transaction in contravention to para 339 of regulation of RBI.
Okay.
Three
That,
people, three people.
there he was found guilty.
My lord, thereafter he left out without reporting the commander. Paragraph 3, my lord.
Right. That
Paragraph 3, my lord.
okay.
It is humbly submitted here that the above mentioned matter has been dealt in accordance with the direction of the higher formation headquarters as per Army rules and regulation 109 Light Air Defense Regiment had given sufficient time to Pratap Chandra Shrestha to report the military authority for pending disciplinary proceeding which he committed while he was in service as per Army Act 123 is liable to face discipline proceeding even after discharge from service. However, the petitioner neither reported nor intimated his present location to avoid undergoing the discipline proceeding. Thereafter, 109 Light Air Defense Regiment was left with no option but to approach civil administration to apprehend the brother of the petitioner legally, who is required to military court for the disciplinary proceeding.
Only to test the discipline.
My lord.
Here my case is, your lordship. There is admittedly there is a proceeding is pending against me. There was a proceeding. I've been convicted. I'm not on that, your lordship. The question is, when I was apprehended from my house, your lordship, without following any procedure led by the Honorable Supreme Court in D.K. Basu case, your lordship, none of my family members was intimated on which charge I have been apprehended, I have been arrested. Neither my brother was produced before the local magistrate, and all these facts came to my knowledge only after filing of affidavit by the state, your lordship, that they have apprehended my brother, they have handed it to the army authority, and my
Have you taken such averment in your writ petition?
yes, your lordship.
Where that this procedure which has been laid down in the CRPC was not followed?
Your lordship, by the time of filing of this writ application, your lordship, that was not within my knowledge that he was handed over.
Then how they will take averment or in that respect? Unless you take pleading on a particular aspect that these are the procedures. How they will respond? Whatever you say, if you say orally, that cannot be a ground to ask them to file or to show that where they have followed it or not. Had you taken
That,
such averment in the petition?
Para 5, your lordship.
Yes, para 5, what you have stated?
You are talking
That
about
the petitioner made query and ascertained that till date no FIR has been registered against his brother in the said place.
That's not whatever you are telling just now.
Article
It's
22. You are
submission. You are that the procedure which has been laid down in the CRPC, Article 22, all these things. Where is the averment that he is to be the family members are to be intimated? All these he has to be produced before the nearest one. So these have not been followed. We are kept in darkness. Where are those specific pleadings?
That, your lordship, 6, 7, 8.
Arnesh Kumar case you are referring to.
DK
11
Basu
DK
case.
Basu.
Sorry,
DK
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 Basu.
Basu case.
Yes. So, where is that averment? Unless you make specific averment, how can they meet it? And now, whatever they have stated, it is on the basis of a proceeding in which you are found guilty and you did not report. That is why whatever legal formalities they are required to be followed, they have followed it. And now your custody or handing over to them was justified in view of the uh, proceeding and that you are found guilty. So how can we say that the detention is illegal or unauthorized?
By the time your
Para,
lordship,
para 7 and 8, you have given little
Yes,
flavor
your
of that,
lordship.
but you have
That-
not
yes, your
elaborated.
lordship. By the time I filed this writ application, your
Read
lordship,
para 7 and 8.
that the OP number 5 is also not allowing any of the family members to contact with the brother of the petitioner, and all are in dark till date. Therefore, petitioner apprehending some foul play by the opposite party in the instance unknown persons, at the instance of unknown persons. Para 8, your lordship, the detention of petitioner brother for more than 24 hours in police custody without any allegations is not only illegal but also violative of
So
Article
at
20.
least
My lord,
now,
these things will arise only when an offense has been committed under the IPC
so
and will be guided by the CRPC. This is not he has not committed an
now,
offense under the IPC.
now you know that your brother, what proceeding is pending against
Yes.
him,
Yes.
how he has been found
Of course, your
guilty,
lordship.
what are the charges against him, and why he was taken by the local police and hand over to the army officers. All these things are known to you now or not?
Yes, your lordship.
So,
And at the time of
At-
at the time of apprehension also, your brother must be knowing all these things. He was
But-
avoiding.
Yes,
but-
it was
But
Avoid-
at the time of apprehension, your lordship, they should have intimated the family persons
No.
regarding
Has your
under
brother
under
intimated-
under which.
Has your brother intimated you that I have committed this kind of thing and I have been
No, yes, sir. By
But
complying
you-
complying the
Army-
procedure of arrest, your
Army
lordship.
personnel as a notice.
Complying the
House of the-
procedure of arrest, your lordship, the family members, and there has to be some witnesses. There has to be some signature of some witnesses.
all right.
Your lordship may
He's-
peruse the counter filed by the IIC himself, your lordship. The arrest memo, handing over memo, and in none of the document, any of the family members' signature available, your lordship.
No,
Nor any independent
Annex-
person's signature, your lordship.
Annexed
So
D
that
by 5
itself-
is Annexed
that
D by 5 is addressed to Pratap Chandra Shrestha. It is in his knowledge that with reference to the I am to say that you are required to surrender yourself immediately at any cost before the colonel,
which annexes-
commanding officer. That is D by 5 of
That affidavit which has been
the
filed by opposite party,
initial counter, my lord,
opposite
filed
party
by-
number
OP number 5.
5.
That is, my lord, that was filed in a month of
Annexure, that is the first one.
7/7/20 in
Yes,
July
first one,
2022.
Right.
Yes.
The counter they filed in 7/7/2020, your lordship. The state has annexed some of the documents, your lordship.
This is the letter which has been issued.
Annexed D by 5.
Superintendent of Police, Ganja. That is the letter. You are requested to initiate requisites measure, paragraph 2, at the earliest to apprehend the above named individual for completion of pending disciplinary proceeding. Once the individual has been apprehended, surrenders, please inform the nearest military station accordingly. Please contact with so and so.
Just see this.
Yes, your lordship. But they have
And your lordship,
My-
you see,
my
Annexed
contention
D
is,
by
sir.
5 at page 9 of the same counter.
D by 5.
Again, page 9, my lords. This is addressed to him.
To so and so, letter of so and so regarding disciplinary proceeding against so and so. Okay, with reference to that, I am to say that you are required to surrender yourself immediately to at any cost.
And that is on
Before
18th,
Swans.
18th
I-
February, same day.
18th February 2022. No, they said
the,
18th
the,
February.
the address is different, your lordship.
ଆଗରୁ ଚିଠି ଗୁଡା ଦେଇଛନ୍ତି ଏଇଟା ଫାଇନାଲ ଲେଟର ଏଇ ଯୋଉ ରେଫରେନ୍ସ କୁହାଯାଇଛି ନା ଯେ ଏଇ ଯୋଉ ଏଇଗୁଡାକ ତେଣୁ so since alternative action is not 18 to 2022.
Right, sir, put it in. Yes, like I feel it. You see, and
ଏଇଟା
witness করে করছেন সব।
18 to 22 the letter, he has been handed over on 18/3/2022.
Hmm.
Sir,
When
please,
when your brother was taken from the house?
On 17 on
No.
17/3/2022, Your Lordship.
17th.
Your Lordship, kindly have glanced.
That means
my
after this letter also he did not respond.
no, he did not respond.
That
That is
letter
that.
is in different address.
See,
Your Lordship.
What
one
difference?
month before the letter was addressed. That
Yes,
is
Your
on
Lordship.
18th February 2020.
Yes, Your Lordship.
ଆପଣ ଏଟା ଆଡ୍ରେସ ଅଛି କପି ଫରୱାର୍ଡ ହେଇଛି ଏଟା ଆଇଆଇସି କୁ ମଧ୍ୟ ଫରୱାର୍ଡ ହେଇଛି ଆପଣଙ୍କୁ ନିଜକୁ କପି ଯାଇଛି ଏଇଟା ଆଡ୍ରେସ ଯୋଉଟା ଠିକ ଅଛି ନା ନାଇଁ?
Immediately after apprehension of my brother, Your Lordship, he was not produced
not
before the
required.
nearest
Yes.
magistrate, Your Lordship.
It is not required by law.
And
The address is wrong.
no family member's signature was taken while apprehending my brother, Your Lordship. No procedure was followed, Your Lordship, while apprehending my brother, Your Lordship. And straight away he was given custody to the army. And after 1 month, Your Lordship, and Your Lordship may peruse, I have given several letters to the authority, Your Lordship, by registered post.
Mr. Counsel, there is no averment at all. Again, we are repeating the same thing. Where is the averment that this thing has not been done, that thing has not been done? How they will reply? Are you following it? Unless there is specific pleading in your writ petition that these were required to be followed as per the DK Basu's case or as per the provisions of the CRPC or Article 22, all these things, and that has not been followed in this case. Unless that is taken, you will just say,
I may be permitted to amend my writ application,
How-
Your Lordship,
what
in
did
view
you
in view of the changing circumstance, Your Lordship, because the date of filing, Your Lordship, this was not within my knowledge.
what benefit now you will
Now
get?
it-
Your child, your brother is now facing the disciplinary proceeding, and the result, whatever it may be, what will happen. Now he is in before his employer. They have initiated the proceeding. You know that now keeping this pending
habeas
proceeding
corpus
pen-
file?
Rather,
It's
he
not-
Because Your
concentrate there,
Lordship,
getting
yeah,
energy
right.
instead
Because
of wasting
it's
energy.
unnecessary.
because Your Lordship, by
No fruitful result would
they have
come
not
unless
followed the procedure, Your Lordship,
it's all right.
during course of apprehension, Your Lordship.
All right. The
None of
petitioner,
the family members were
All right.
intimated, no
The-
signature was taken, Your Lordship.
the petitioner Pradeep Kumar Shrestha has filed this writ petition in nature of habeas corpus.
Pradeep Chandra.
Pradeep Kumar লেখা হয়েছে?
Chandra লেখা আছে। Chandra, Pradeep Chandra. Pradeep Chandra na Pradeep Kumar?
Kumar.
Pradeep Kumar.
Pradeep Kumar. With a prayer as to why the detention of his petition
Army is Pratap Chandra. Brother of the petitioner is Pratap Chandra.
ନାଇଁ ପିଟିସନର ହଉଛି ପ୍ରଦୀପ କୁମାର
Pradeep Kumar.
ଶ୍ରେଷ୍ଠ।
ଆଜ୍ଞା।
ଏଇଟା ଜନତା
Army
ଭାଇ-
ତାର ଭାଇ।
He Pradeep Kumar.
uh,
Army hochi Pratap
Pratap
Chandra.
Chandra.
Pratap Chandra.
right, as to why the detention of his brother, namely Pratap Chandra Shrestha, by the IAC of Aska police station shall not be declared as illegal, and why appropriate direction shall not be issued to release him from police custody forthwith. In the writ petition, it is averred that the brother of the petitioner is an ex-army personnel, and during his job, one disciplinary proceeding was initiated by the commandant of his wing, and in the meantime, Pratap Chandra Shrestha retired from his job And on 17/3/2022, around 7:15 p.m., all of a sudden, 4 local police personnel of Aska police station came to the house of the petitioner and forcibly dragged Pratap Chandra Sreshta from home, even after being objected by the petitioner and his family members. Though it was intimated to the family members that there is a cognizable offence pending against against Pratap Chandra Sreshta, and by court order they were bound to arrest him. But when the petitioner demanded the copy of such order, neither the IIC of Aska police station nor any of his staff shown any such copy. No document or any order or letter was shown to the petitioner and Pratap Chandra's sister when he was taken to the police custody. It is the further case of the petitioner that the petitioner and his family members came to Aska police station and tried to meet Pratap Chandra Sreshta, but the IIC refused to do so. And asked them to come on the next day, that is on 18/3/2022. And on 18/3/2022, when the petitioner and his family members came to the police station and tried to meet Pratap Chandra Sreshta, they were told that he is not in their custody and handed over to army personnel, came from New Delhi. It is stated that the family members, the petitioner and his family members were kept in darkness till date, till the filing of the writ petition. About Pratap Chandra Sreshta, whereabouts of Pratap Chandra Sreshta. And they have detained him without any allegation, and that the police officials of Aska police station exceeded their jurisdiction. After notice was issued, comma, the opposite party number 5 that is inspector in charge of Aska police station filed the counter affidavit wherein it is indicated as follows, quote, paragraph number 2, then 5, then 7, and 8. The opposite party number 6 that is commanding officer so and so also filed an affidavit wherein it is mentioned as follows, quote, paragraph number 2, 3, 4, 5, 6, 7, and 8. A further affidavit has been filed by the opposite party number 5 on behalf of opposite parties number 1 to 5 pursuant to the order of this court dated 9/3/2023. Wherein it is mentioned as follows, quote, paragraph number 4, only 4. After hearing the learned counsel for the respective parties, we find that the brother of the petitioner, namely Pratap Chandra Shrestha, who was the Havildar operator, bracket operator, of 109 Light Air Defense Regiment, bracket self-propelled, was arrested due to non-compliance of the orders to surrender himself for implementation of the orders of inquiry, in which he was found guilty for the offense on 26/7/2020. We further found that as per the direction of the higher formation oblique headquarters as per Army rules and regulation 109 Light Air Defense Regiment self-propelled had given sufficient time to Pratap Chandra Shrestha to report to military authority for pending disciplinary proceeding which he committed while he was in service, and as per Army Act Section 123 of Army Act, is liable to face the disciplinary proceeding even after discharge from service. But the brother of the petitioner neither reported nor intimated his present location to avoid the ongoing disciplinary proceeding, for which 109 Light Air Defense Regiment self-propelled was left with no option but to approach the civil administration to apprehend the brother of the petitioner legally, who was required by military court for further disciplinary proceeding. Though the London Counsel for the petitioner urged that at the time of arrest, it was not intimated to the family members of the petitioner as to why his brother is taken into custody, and the arrest memo was not prepared, and the brother of the petitioner was not produced before the magistrate within 24 hours, and therefore the ratio let down in the case of D.K. Basu by the Honorable Supreme Court, Swanswajit Purata Devala, has been flouted in the case. But we find that there is no specific averment to that effect in the writ petition. In view of the foregoing discussions, when we find that the brother of the petitioner has been taken into custody in accordance with law, and his detention by the army authorities cannot be said to be illegal or wrongful in view of this series of letters annexed to the counter affidavits, and keeping in view the provisions under section 104 and 123 of the Army Act 1950. We are of the view that this writ petition is not maintainable in the eye of law. Accordingly, stands dismissed. Yes, next. Respective counsel.
May I pardon my lord in virtual? Serial 4.
Item 4.
Yes, sir.
Pardon me. So the petitioner is the husband, and the lieu of a affair from by the wife. The police have forcefully taken the kids from the custody of the father, and their education is very badly hampered, and they are now staying with the mother. But there is a family dispute between the father and the wife, mother. Because of that, they filed a FIR in.
No, your two children, they are now staying in the company of your wife. That
Wife.
means their mother.
Mother.
So how the custody of the children with the mother can be said to be illegal or wrongful, so that we'll entertain this application. If you want their custody, appropriate remedy under different acts that is available to you, you approach the appropriate court, seek for appropriate
Here is the
remedy.
case that
How?
police interfered in the matter. Police forcefully taken away.
No, you
Mother has a
yourself,
love affair. That's but in the
it's
lieu
all
of that affair,
you yourself has is now submitting that the two children are with their mother,
my lord. This is
right?
the pleading. This is also
So if the children are staying with their mother, if you are interested to have their custody or any of them, or you want the visiting rights, whatever it may be, so the appropriate remedy is available with you. So these are the decision of the Honorable Supreme Court in Tejaswini Gaud case and the other cases. We have just disposed of one of such matter.
And
My-
item 1, you were there, where you heard item 1?
item 1 is the influences. Item 2
No,
and
no, item 2, sorry, item 2.
item 2.
Yes.
Item 2. There is a reverse one. Wife has a complaint regarding the.
All right, the same principle is same. They have stated that it's an
But my lord, here
extraordinary.
big difference is that the police has interfered. Illegal police has here is a family matrimonial dispute and it's
Second
regarding the
judgment.
custody.
Second judgment which we were relying upon, that is ACR, that is the wife's custody, the same facts,
My lord,
exactly the same facts.
my lord, my lord.
Approach the appropriate authority. Take down. The petitioner, Dinabandhu Mahapatra, has filed this writ petition, nature of habeas corpus, with a prayer for a direction, production of his children before this court. The Land Counsel for the petitioner submitted that the petitioner married to the opposite party number 3 on 3/3/2014, and out of their wedlock, 2 sons were born, who are now aged about 8 years and 4 years.
One son and one daughter.
Acha, one son and one.
One son on that.
One son and one daughter. And it is further submitted that both the children have been admitted in the school, and but they are now with the opposite party number 3, and as there was a dispute between between the petitioner and the opposite party number 3, they are residing separately, and the police has intervened in the matter and taken the children from his lawful custody and handed over them to the custody of opposite party number 3 illegally. The Land Council further submitted that without taking resort to the provision of law contemplated under Section 6 of the Hindu Minority and Guardianship Act 1956, the police has assisted the opposite party number 3 in taking the children from the lawful custody of the petitioner and handing over them to the custody of their mother. The Land Council for the state submitted that this.
Let's say in this case, the OP number 2, the IIC has filed an affidavit.
Acha.
The-
The in persons of the order of this court, the inspector in charge, inspector in charge ना सब inspector कौन लिखा है जी उटा अर्चना छोटरा है तो
Aye, madam.
the sub inspector of town police station Barghat has filed an affidavit, counter affidavit.
Yes, Lord. Let's say kindly have a glance to page 16 of that affidavit.
16.
Let's say a note is there. It is a CD copy, Your Lordship.
It's a FIR, page 16.
note would and
ଆପଣ ପେଜ 6 କଥା କହୁଛନ୍ତି 16 କଥା ତ 16 ତ ଏଫଆଇଆର ଟା ବରଗଡ଼ ଟାଉନ ପିଏସ୍ କେସ୍ ବରଗଡ଼ ପିଏସ୍ କେସ୍ ନମ୍ବର 542 ନା କେତେ ହେଲା
and next is 6 my lord.
I put 2 out to 2
And
I put 2
FIR and next is page 6, Your Lordship.
ହଁ
I'm talking 16.
Annexure 1 page 6 we have
16. After the FIR lodged, my lord,
okay
case diary, Your Lordship, can have a glance. Page 16.
16
notice
of the counter.
okay
of the counter, Your Lordship.
uh-huh.
In that case, police has gone to that place of that husband and the petitioner, and where the parents of the petitioner were present there, and they did not object when the child been taken.
କୋଉଠି କୋଉଠି କେତେ
I'm
କୋଉ
reading
ଡେଟ୍
that portion.
ସିଡି ର କୋଉ ଡେଟ୍ ଟା କହୁଛନ୍ତି
20/11/2000.
20/11 ହଁ ପଢନ୍ତୁ କୋଉ ଲାଇନ ଟା କହୁଛନ୍ତି
Note, Your Lordship. I
Note.
yes,
अच्छा आई मीन पाइले 20 पेज रो एटा 22 पेज इस केस डे पेज
16.
पेज 16 रो एज ऑफ 11 रो that for it 13 14 15 and 16 on note would have according to case yes please read it out.
I may note here that when the children see their mother, they are showing their anxiety to stay with her. Then the complaint asked to her mother-in-law and father-in-law regarding taking of her children with her. They also agreed for the proposal. Finally, the complainant took her children, namely Saspita Mahapatra and Siddharth Mahapatra.
Okay.
My lord, second thing, Your Lordship.
Yeah.
Reading, Your Lordship, page number 35. The 161 statement of the daughter, Your Lordship.
Just underline correct. Page this
35.
is date होची 20/11/2022 केस डायरी एंट्री ओके नोट पोर्शन आ गुडा कोडा कहउजनी
Page 35, Your Lordship.
35
The 161 statement of the daughter, Your Lordship.
wait dot 35
Yeah.
हाँ कौन
Yes, Lordship. Last two line I'm reading.
सस्मिता महापात्र
My lord, my lord. Last two line I'm reading. ମୋ ମା କିଛି କଲେ ମୋ ବାପା ମୋ ମାକୁ ପନିଶ କରନ୍ତି, ଆମକୁ ବି ରାଗନ୍ତି। ପ୍ରଶ୍ନ ବାପା ଓ ମା ମଧ୍ୟରେ କିଏ ଭଲ? ଉତ୍ତର ମା।
but nowhere mentioned that I am willing to stay
And
with
second
mom.
is page 36, the son also, my lord. 161
So
statement.
4 year son statement
all right
And
it
now your lordship is enlightened of about 2021 decision. It is not maintained.
They submitted that the writ petition is not maintainable and it is further argued that at the instance of the opposite party number 3 on the written report presented by the opposite party number 3 before the inspector in charge of Bargarh Police Station, Bargarh PS case number 542, dated 4/9/2022, was instituted under section 498A, 294, 323, 506/34 of the Indian Penal Code and section 4 of Dowry Prohibition Act against the petitioner and other in-laws family members. And during course of investigation, on 20/11/2022, during visit to the house of the petitioner, it was found that the children, seeing the opposite party number 3, showed their anxiety to stay with her. The opposite party number 3 also asked her mother-in-law and father-in-law regarding taking of her children with her, and they also agreed for the proposal. And accordingly, the opposite party number 3 took her children. The Land Council for the state also placed the statements of the 2 children recorded by the investigating officer, from which it reveals that they have stated that their mother is better than their father. The Land Council for the state further submits that the petitioner has alternative remedy for seeking the custody of the 2 children, and the writ petition is not maintainable. Then you refer to those 2 decisions which I have stated in item number 2. Okay. Sethere relevant paragraph guda quote kar diyantu hala. After hearing the Land Council for the respective parties, the counter affidavit filed by the opposite party number 2 and the ratio laid down by the Honorable Supreme Court so and so, we find that there is exceptional case has not been made out by the petitioner to entertain this writ petition. The petitioner has got alternative remedy to approach seeking for the custody of the minor children. Accordingly, this writ petition is disposed of. Yes, next.
Pardon, madam. Item number 3. I have submitted the record of court of inquiry, madam. Last occasion of by order dated 29/3. That can be.
Item number 3, the pursuant to so and so, the record of inquiry has been submitted by the Land Central Government Council, Mr. Panda, and the same may be returned to him. Okay, yeah. Copy Xerox copy retaining a Xerox copy of the same, it is to be returned. Okay.
Obligement.
Item 5.
May I please, Your Lordship?
Yes.
Madam, in this case, minor daughter of the petitioner has been kidnapped since 6th August 2022, madam. Since 6th August 2022, minor daughter of the petitioner has been kidnapped, madam. While he was at that time was only 17 years some months.
You have lost the affair.
Yes, madam. Annexure 1, page 11, madam.
So Is a case of elopement or what, Mr. What is
My
the
lord, in the meantime, your lordship, the report has come. She has already been rescued.
rescued?
Yes.
Handed over to
162 statement also recorded in the meantime.
So what is the age of the victim now? Have you
My lord, at the time of kidnapping, she has only 17 years, 4
no,
months,
no,
my lord.
just tell me what is the recent what is the date of birth? Any documentary evidence with you?
15 for 2005, my lord.
Huh?
15 for 2005, my lord.
Have you filed? Have you
Yes,
filed?
my lord. Yes, my lord.
Which
An-
annexure?
Annexure 3 is the board certificate and Annexure 4 is the VAS certificate, my lord.
Annexure 4.
Yes, my lord. Page 16, my lord.
Okay, date of birth it is given as 7/4/2005,
Yes, my lord.
right?
Yes, my lord.
So 7/4/2005 means she has completed the 18 years of age.
But on the time of kidnap, my lord, she was only 17 years, 4 months.
It's all right when she was produced before the court. Now, since she has become major, she expressed her willingness to stay with her uncle Mausa ଏବଂ ସେ ନିଜେ କହୁଛି ଯେ ମୋ ବାପା କୁ ଉପରେ ରାଗିକିନି ତାଙ୍କ ମୁଁ ଘର ଛାଡିଛି ଏବଂ ଯାଇକିନି ଭବ ଶଙ୍କର ଗିରି କୁ ବର୍ତ୍ତମାନ ମୁଁ ବାହା ହେଇଛି ମୋ ନିଜ ଇଚ୍ଛାରେ। ଏହା ହଉଛି ତାର 164 ଷ୍ଟେଟମେଣ୍ଟ। ବର୍ତ୍ତମାନ ମୁଁ ମଉସାଙ୍କ ସହିତ ଯିବାକୁ ଚାହୁଁଛି ଏବଂ ରିଟିନ୍ କନସେଣ୍ଟ ଦେଇକିନି ଯାଇକିନି ମଉସାଙ୍କ ପାଖରେ ବର୍ତ୍ତମାନ ରହିଛି। So that is the
My
so
lord,
how
she might have biased, my lord. But
biased.
at the time of kidnapping, she
Now
was
she
only
is
74 months.
according to you also now she is major or not?
Now she is major,
So
my lord.
ଆଉ ଏ statement ଟା ଯୋଉ record ହେଲା ସେ major ହେଲା ପରେ record ହେଇଛି ନା ନାହିଁ? ଏ ଯୋଉ 164
That is not in policy,
that
my
is the report of the that it was recorded by the London magistrate under section 164 CRPC and she has stated like this. If you want to verify, you can go to the verify the case record. You will find that. So why don't you hand over a copy of this? Just hand over.
She married on 8/4/2023.
Right,
just completion of 18 year, my lord.
right, right.
But at the time of kidnap, she was only 17 years, 4 months, my lord.
This writ petition has been filed by in the nature of habeas corpus has been filed by Baburam Giri. With a prayer for direction to the opposite party inter alia করন্তু to rescue the minor daughter of the petitioner from the clutches of the kidnapper in connection with Talsari Marine PS case number 30 dated 7/8/2022 in the district of Balasore and for production of the minor daughter before this court. The land counsel for the petitioner submitted that date of birth certificate of the victim indicates or date of birth to be the birth certificate or indicate or date of birth to be 7 4 না এটা কেতে 9
4 minor.
7 4 ଆଦେରେ କଣ ଏପଟ ସେପଟ କରିଛନ୍ତି କି କଣ 7 4 2005 ଓଭର ରାଇଟିଂ ହେଇଛି
ଆଉ କଣ ଅଛି କି ଡକ୍ୟୁମେଣ୍ଟ ଆପଣଙ୍କର?
Annexure,
Annexure 3 ଟା ଅଛି।
3
Yes, sir.
ଏଇଟା କଣ?
annexure
Board.
3.
এটা বোর্ড
Basic
বোর্ড
data.
রয়েছে হ্যাঁ 7 4 2005 ঠিক আছে 7 4 2005 so also the certificate board of secondary education certificate and the petitioner lodged the first information report before the inspector in charge of Talsari Marine Police Station on 7/8/2022 for which Talsari Marine PS case number 38 dated 7/8/2022 was registered under section 363 of the Indian Penal Code against known person Bhava against Bhava Shankar Giri. Even though it is the case of the petitioner that Bhava Shankar Giri has kidnapped his minor daughter, but he has not been arraigned as a party in the writ petition. However, in pursuance of the order of this court, the IIC Talsari Marine Police Station has submitted the status report from which it appears that on 36/2023, the victim girl was rescued and intimation was given to her parents to cooperate with investigation. It further reveals that the statement of the victim girl was recorded and then she was sent to CHC Jaleswar Pur for her medical examination, and then she was produced before in the court of Graman Nyalaya cum JMFC Bhugrai for recording of her statement under section 164 CRPC. And she stated that she left her house towards Hyderabad, being angry on her parents, and on 8/4/2023 she married to Bhava Shankar Giri, and on her sweet will, and after recording of the 164 CRPC statement, the victim gave a written consent to go with her uncle bracketry Mousa. The status report is taken on record in view of the state of affair, since the victim is now major, and after a recording of her 164 CRPC statement and with her written consent, she is now staying with her uncle. We are not inclined to pass any further order in this writ petition, which is accordingly disposed of. Yes, next.
Item 6.
Mr. Hirot Kumar Pahil. What is this, Mr. Tripathi?
This is also my lord, the girl has been rescued in the meantime.
Girl is rescued and
Actually been forwarded to the
Who is appearing for petitioner?
Oh no, what happened to the girl after rescue?
Rescued, she was taken by her parents.
Parents?
Right.
Okay, okay, that is the reason why perhaps he is not appearing. All right. Non-appears for the petitioner. In this writ petition, petitioner Nityananda Palai has prayed for writ petition in the nature of habeas corpus, prayed for a direction to the opposite party number 1 to 4 to rescue his minor child and to produce before this court the London Council for the State has produced the status report of IIC Rajkanika Police Station, Kendrapada, from which it reveals that on the report of the petitioner, that his daughter was aged about 17 years and had gone to college, didn't return, and one Shivam Gupta had kidnapped his daughter by pretending love to her. Rajkanika PS case number 150 dated 25/2/2023 was registered under section 363 of the Indian Penal Code. It is further stated that during course of investigation from the after the seizure of the school admission register, where the victim was prosecuting her studies, it was found her date of birth was 17 to 2006 and her age as on the date of occurrence was 17 years 8 days, and she was minor. It is further found that on 7/5/2023, the victim girl was rescued from Debulpur, Hyderabad, and the accused was also apprehended from the same place by the IO. The statement of the minor girl under section 164 CRPC has been recorded in the Court of Law and Additional Session Judge Kendrapada, and the accused was forwarded to the said court on 8/5/2023 after his medical examination, and the victim minor girl has also been handed over to her parents after proper formalities. In view of the status report submitted by the IIC Rajkanika Police Station, since the PS case which was instituted at the instance of the petitioner is under investigation and the victim has already been rescued and handed over to her parents, we are not inclined to pass any orders, further orders পর্যন্ত আগুর কিছু অর্ডার হইছিল কি আদের further orders in this writ petition according which is accordingly disposed of. Yes, next.
Item 7.
Yes, Mr. Das. এটা কোন হইছিল লাস্ট টাইম? Actually, once is a case file there is a registered FIR and investigation started matter. At the time of the FIR, in the once is case, they have mentioned that there is the age is 17, minor girl. But after verification of the school administration, it is more than 18 years, 19 years.
So, what happened to that girl?
But we are trying to test out. It has not been tested out. And last, even in the last 4 days, the new IS and IO has been changed, joined my law. So let me give some time. So I.
No, the person's names are very much there.
Yes, yes, madam.
They have not yet been apprehended.
No, no, madam, not apprehended.
And what
And their
about
mobiles are also switched up, and they are also trying in different places, madam.
no, whatever it may be, you
Yes,
should
madam.
file your status report,
Madam.
whatever you have
Madam,
done,
let it be-
and also the case diary also.
Madam.
What progress you have made, because this FIR,
Madam.
it seems that it was lodged on 26/4/2023.
Madam.
So almost 5 months or 4 months at least is now over.
Madam.
And you said that let us
And
say that
last of the 22/6/2023 report is with me, my lord. So the recent report I have not received because yesterday I talked to the IAC. They joined it 4 days back, my lord. Let it be give some time.
The petitioner is not happy.
Right.
petitioner is the how the petitioner is related to that mother or what? This petitioner to that girl?
My lord.
Yes, minor daughter means mother.
Mother.
Okay. No, the victim is now what is the age of, you say?
My date of birth is 19/8/2023, 2003, my lord.
3 month মানে
19 ବର୍ଷ 7 ମାସ at the time of
मेजर
operation.
ହେଇଗଲାଣି
Major,
ଆଚ୍ଛା ଆଉ ଇଏ କଣ ତା ବୟସ 35 ଜମା ଦେଖେଇଛି
17 ବର୍ଷ ଲେଖିଛି।
mother,
mother.
ମଦର 35 ବର୍ଷ ଦେଖେଇଛି ତାଙ୍କର କଣ 15 ବର୍ଷର ବାହାଘର ହେଇଗଲା ନା କଣ?
ଆପଣ verify କୋଉଠୁ କରିଥିଲେ?
School administration.
Do you have those?
Yes, I have the report.
You have not filed, huh?
Why are you not filing those?
My last occasion, I am sending it.
କୋଉଟା ପିରେ ଏଇଟା ଦେଖାଯାଉନି ଏଠି କଣ କିଛି ଦେଖାଯାଉନି ଏଇଟା କଣ ଆଚ୍ଛା ଏଇଟା ଗୋଟେ this is to certify so and so.
What is this document?
এটা তো হচ্ছে
Jagatpadi
প্রাথমিক বিদ্যালয় primary school law.
Headmaster has given me.
Oh, no, it's all right. It's a date of birth entry is there.
Hello.
No, we just want that what progress you have made so far.
Let me
For
give
that,
some
that,
time, sir.
that you file with an affidavit
Madam.
and what attempts you have taken, particularly when more than 4 months have passed.
Madam.
Petitioner counsel kora hole note there. Ki achen Mulya Ratna Panda. All right, non appears for the petitioner. This petition in the nature of habeas corpus has been filed, seeking for a direction to the opposite parties to cause production of the minor daughter of the petitioner. Land counsel for the state submitted that at the instance of the petitioner, complaint petition was filed in the court of JMFC City, Balasore by 1cc case number 37 of 2023, and the same was referred to the IIC of Chandipur Police Station under section 156(3) CRPC, and accordingly Chandipur PS case number 53 dated 26/4/2023 was registered under section 366A 506 of the Indian by 34 of the Indian Penal Code against 5 accused persons. And the investigation of the case is under progress. However,
during course of investigation, the oh, primary school where the victim was prosecuting her studies was visited by the IO, and the school admission register and the birth certificate was collected from the school, and it was found that the date of birth of the victim was 19/8/2003, and as such the victim is now major. However, the Land Council for the state submitted that till date neither the victim has been rescued in spite of sincere effort of the police, nor any of the accused persons have been arrested. He requires some further time to file an affidavit of the IO oblique the IIC of Chandpur police station relating to the development made in the investigation of Chandpur PS case number 53 of 2023, and also the steps taken by the police to rescue the victim. The Land Council for the state shall also produce the case diary of the aforesaid PS case on the next date. केबे रखियो कुहतु 25 तारिख रखियो this matter will be commencing from 25th September 2023. Yes. Free copy of the order be handed over to the Land Council for the state.
happened, my lord? My lord, ये
He's a major.
my lord, major, my lord. What happened, my lord? My lord, से जो ये गोटे जे पिलाटी नहीं से गोटे ड्राइवर टे my lord. तार तीनोटी स्त्री my lord. बर्तमान से तार काम होची खाली जहाँ बड़ बड़िया लोकन घरे जाके ड्राइविंग करिवो तांको झियो टिके नेकी पळेबो एवं ताटू पैसा नबो my lord एबे से पैसा मागे आरंभ कर देछि ता भौणी फोन करछि पैसा पाई my lord हम पाखे मोबाइल रेकॉर्डिंग अछि पुलिस किछि स्टेप नउनी my lord एते गुडे दिन हे गेला
When the FIR was lost?
my lord, missing report, my lord.
No, just FIR is dated 7/6/2023.
My lord.
Okay.
My lord.
And what order was passed previously in this case?
My lord. My lord, on dated 7/7/2023, my lord.
That's important.
7/7/23.
My
So and so opposite party taken away daughter who is admittedly major. It has been disclosed in the missing report so and so that her daughter has sent a WhatsApp message stating that she has voluntarily left the house with the opposite party number 5. However, the said message had come. Okay, under such we think it that it would be appropriate to direct the opposite party number 3 and 4 to locate the victim and record her statement as no so and so. Major who leaves the company voluntarily, as such we direct this so and so. So, what is your instruction, Mr.?
Well, I have submitted a report, my lord.
Okay.
Last and 17/8/2023, team of has gone travel to Chennai, my lord, to trace the victim, but could not rescue, my lord. That is as per the report dated 23/8/2023, my lord. And prior to that, also traveled to, my lord, Andhra Pradesh to test out, my lord. We're taking steps, but no fruitful result has come, my lord. But we were also trying.
My lord, एबे तंग भौणी फोन करिके कहउछन्ती पैसा दियो बोली
कौन पैसा देन
पैसा देले हमें छाड़ी दो
का भौणी
से जो my lord जो ड्राइवर जनक नै छथि
Why are you not handing over the
my lord सब
record it?
my lord मोबाइल रेकॉर्डिंग सह मोबाइल नंबर सह नै पुलिस स्टेशन ने देइछु ଏବେ ଦେଇଛୁ ନାଇଁ କି
ଏବେ?
10 ଦିନ ଖଣ୍ଡେ ହବ।
I have to take instruction, my lord.
Take instruction on that. So, but
You give a copy to whom of this?
Yes, ma'am.
यार ଗୋଟେ copy ଦିଅନ୍ତୁ।
Very
alright. So same date ରଖୁଛୁ ଆପଣ latest
Yeah.
development ଆଣନ୍ତୁ କଣ ହେବ। ଦେଖନ୍ତୁ the in portions of the order dated 4/8/2023. The Land Council for the state has produced the report of the IAC Bharatpur police station dated 23/8/2023, from which it reveals that the inquiry officer searched all relatives and friends and bus stand, railway station to trace out the missing girl. Subject ଉପରେ ଟିକେ ଲେଖିଦେବେ ଏଇଥିପାଇଁ ଫାଇଲ ହେଇଛି ବୋଲି ନା ଏବଂ ଏଇ ଅର୍ଡର ହେଇଥିଲା ତ। And on 17/8/2023, one officer, namely State SI of Police S.K.SAHOO, traveled to Chennai to trace the missing girl, but no positive result came out. And the inquiring officer is taking all sincere steps to trace out the missing girl. The Land Council for the state submitted that the victim girl is now Major. The Land Council for the petitioner, on the other hand, submitted that the accused in this case is a married person, and few days back the କିଏ ଫୋନ କାହା ପାଖକୁ
ତାଙ୍କ
ଫୋନ
ଭଉଣୀ ମାନେ ଯିଏ ନେଇଛନ୍ତି ସେ ଯୋଉ ଡ୍ରାଇଭର ଜଣକ ନେଇଛନ୍ତି ତାଙ୍କ ଭଉଣୀ ଫୋନ କରିକି କହୁଛନ୍ତି ଯେ ପଇସା ଦେ।
The sister of the accused made a telephone call
ମାଇଲର
and intimated କାହାକୁ intimation
the petitioner's wife ମାଇଲର ମାନେ
and intimated the wife of the petitioner that demanding money to leave the victim, and it was recorded in the mobile phone, and the same was handed over to the inspector in charge of who police station?
Bharatpur police station.
Bharatpur police station. The Land Council for the state submitted that he has no instruction in that respect, and he may be given some time to ascertain from the IAC whether any such recording has been handed over to him, and if so, what steps have been taken by the IAC. As prayed for, list this matter in the week commencing from 25th September 2023. Free copy of the order be handed over to the Land Council for the state. It is taken on record for the
obligement.
Weekly list item number 1.
Present whereabouts ମଗା ହେଇଥିଲା?
The
So
present whereabouts one?
he's alive and he's healthy.
No, he is on bail.
He's on bail.
No, but what about the council? Otherwise, we'll engage amicus curiae.
Mr. Subhash Chandra Pradhan and Mr. B.S. Das Parida.
B.S. Das Parida means the associate of Mr. Dhar. Oh, why don't you? B.S. Das Parida is the associate of Mr. Dhar. His other associate is also. Where is Mr. Parida? अरे तो ना लिखा है जी पूरा B.S. Das Parida.
I will inform your lordship right now.
Just inform, ask him to come.
Yes, your lordship.
2004 jail criminal appeal,
Idea.
302 case. Okay, call the next one.
Item 2.
May I please, your lordship. This case, my lord, the appellant released on bail 9/8/11, my lord. Since a jail criminal appeal, my lord, the whereabouts of the appellant as earlier occasion call for, my lord.
Yes, Mr. Tripathi.
Yes, my lord. Instruction I have received of 20/3/2023, where it has been stated he is health and happy.
Huh?
Hell and happy, alive.
So, he's on bail.
My lord.
On bail, my lord.
Argue your case.
My lord. This case, my lord. In this case, conviction order
At a
302.
Land counsel for this so and so, as per the order dated so and so, has obtained instruction that the appellant is alive and is residing in the village so and so. It taken on record for them. So, what are the charges, Mr.
What
Rogan?
are the charges? 302, section 25 and 27 Arms Act, my lord. But ultimately, has been acquitted from the charges under section 25 Arms Act, but convicted under section 302 and 27 of Arms Act. And a sentence, my lord, undergo RI for life to pay fine up to 10,000, default to undergo RI for 6 months. So far, 302 IPC is concerned. Further sentence to undergo RI for 3 years to pay fine up to 2,000 and default RI 2 years under section 27 of Arms Act.
So, the name of the deceased is Natha
Kisan. Natha Kisan.
Okay, you come to the FIR, let
My
us
lord.
see.
FIR, my lord. मोर नाम शिवश्च किसान बयस 35 वर्ष पिता नाथ किसान निज भंगा मुंडा कांचनपुर थाना किसिंडा जिला संबलपुर आज 16/4/2069
informant is PW?
One son of the deceased man. 6:45 समय किसिंडा थाना पलसा खली गाँव जिष्णु किसान परमेश्वर किसान एवं देदरा गाँव जयराम किसान सहित हाजर होई आपनक आगे यही मौखिक रिपोर्ट देउछि जे गत श्रावण मासरे मोर सान भाई गणपति किसान क्षेत्र में हल करुवा बेले गोटे गोरु बलद मरी जाइथिबारु ताकू गोवधर दोष लागिथिला। तेणु आम जाति समाजर नियम अनुसार गणपति किसान गोबध दोषरु मुक्त करिया पई आज 16/4/2069 तारिख दिन शंख नलर देदरा तापरे 2 गोटी बोदा नहीं जाति समाज लोक मानकु खाइबाकु देउथिलु। दिन प्राय 2:30 समय आम किसान समाजर फलसा खली और देदरा गाँव प्राय 30 जन पुरुष लोक उक्त भोजी रे खाइबा बेले पलसा खली गाँव महादेव किसान अपलेंट पिता फगु किसान तार बड़ बापा सुकु किसान सहित मांस खाइबा बाबद झगड़ा है। यह शुणी परमेश्वर किसान झगड़ा न लगे महादेव किसान कहले किंतु महादेव किसान तांको कथा न मानी उक्तक्त होई मु देखीदेवी कही खाइबा जगह उठी जाई बाकी थिबा भात डाली मांस डेक्ची रे धूली पकई देला और मु देखीदेवी कही तार घर आड़कू दौड़ी पलई गला। किछि समय परे महादेव किसान गोटे देशी बंधुक आनी देदरा टापरे भोजी खाउथिबा लोक मानकू गुली करी मारिदेवी कही दौड़ी बुलाइला। तापरे आमे खाई बसुवा जगह पाखु महादेव किसान उत्तक्त अवस्था रे आसी प्राय 30 फुट दूर ठिया होई शुक्रु किसान को मारिदेव बोली धमक देला। शुक्रु PW3 माइल धमक देला। यह देखी मोर बापा नाथ किसान खाई बसिथिबा जगह ठिया होई महादेव किसान को बुझाइबाकू चेष्टा कला किंतु महादेव किसान रागी जाई मोर बापा नाथ किसान को टर्न कही से महादेव किसान को धरी थिबा बंदूक रे गुली फुटाई देला। फल रे मोर बापा डान हाथ खुआरे गुली बाजी मोर बापा तले पड़ी गले।
ଓ ଘଟଣାସ୍ଥଳରେ ମୋର ବାପା ମରିଗଲେ। ଏହା ଦେଖି ମୁଁ ତଥା ମୋର ଖାଇ ବସିଥିବା ଅନ୍ୟମାନେ ଲୋକମାନେ ମହାଦେବ କିଷାନକୁ ଦୌଡ଼ି ଯାଇ ମାଡ଼ି ବସି ଧରି ପକାଇବାରୁ ତା ଠାରୁ ଉକ୍ତ ଗୁଳି ଫୁଟାଥିବା ବନ୍ଧୁକୁ ମଧ୍ୟ ଛଡ଼ାଇ ରଖିଛୁ। ମହାଦେବ କିଷାନକୁ ଉକ୍ତ ବନ୍ଧୁକକୁ ଘଟଣାସ୍ଥଳରେ ଆମର ଅନ୍ୟାନ୍ୟ ଲୋକମାନେ ଧରି ରଖିଛନ୍ତି। ଏଣୁ ଏହି ରିପୋର୍ଟ କଲୁ, ଏହାର ତଦନ୍ତ କରାଯାଉ। ମୋ କହିବା ମୁତାବକ ଲେଖି ପଢ଼ି ଶୁଣାଇ ଦେବାରେ ଠିକ ଜାଣି ମୋର ଚିତ୍ତ ଦେଲି।
So this occurrence, as it appears, it took place on 16/4/99, and when the deceased died.
Same day, my lord.
Same day.
Same day. The spot.
Okay.
PWD the postmortem doctor.
So eyewitnesses are there.
My lord, 18/4 the postmortem conductor 18/4/99.
No, it's all right, but the occurrence was reported on the very day.
Very day.
Because the date of occurrence is 16/4, FIR shows it was
16.
also registered under section 302
My lord.
on 16/4/99.
My lord.
So eyewitnesses.
There are eyewitnesses 1, 2, 3, 4, 5, 6, my lord.
PWs 1, 2, 3,
And
4 and 5.
5, 6.
Only 1, 2, 3, 4.
Name of the PW. PW3 Sukrupu Kishan.
My lord.
1, 2, 3, 5, 6 এই 5 জন তো
না সে paragraph 7 লেখা আছে prosecution support of the case examine 12 witnesses whom PW1 the informant to the eyewitnesses 2 to 6 are other eyewitnesses to the incident.
मतलब कौन
One of the
5 नंबरটা eyewitness না eyewitness তো
2 to 6 are eyewitnesses.
ओके 1 नंबर नुहे
1 नंबर आ 2
से एकाथरे कोना
1 2 3 4 5 6.
So let us go to one. The cause of death is which
due to
doctor?
shock and hemorrhage due to gunshot injury on the lungs.
Doctor.
PW8.
PW8 PM doctor. Okay. These are all eyewitnesses. So let us come to that doctor's evidence. Let us see. So
PW8, my lord. On 18/4, page 49.
Yes.
On 18/4/99, I was assistant surgeon, ST Hospital, Rerakol. On that day, on police request, I conducted the postmortem examination over the dead body of a deceased Natha Kisan, son of late Monei Kisan of village Bhangumunda, on at 7:15 a.m. being identified by Constable SAHOO, CD SAHOO, Gramorakhi, and other, and found the following external injuries.
After 2 days.
After 2 days, postmortem exams. Mouth
so,
open.
No, it's all right. There are injuries are there. Then internal injury also same, and cause of death is just so.
The last page 50, last paragraph. The cause of death is due to shock and hemorrhage as a result of injuries to the vital organ like lung.
Okay, then the gunshot was made.
My lord.
On at a distance of
30 feet, as per FR story.
No, 1 to 2 meters. It was from a close range. The gunshot was made. We must have that blackening, etc., from which he has determined penetrating wound is there and entering into the chest cavity. Number 2, that is 1. Then lacerated wound is there, so and so.
Exit wound is not there.
Margin so and so. Okay. Another 5 lacerated wound is there. The area of so and so. Injuries are likely to be exit one. Exit one. 3 number touch. So both. All right. 5टा माने आपनकर ई कोन यो ये गुडा किसी जो छरा भଳି number of pellets एकत्र बाहर ସେଇଥିରେ ଅଛି ସେଇଥିରେ ଇଏ ଅଛି. And he opined that it is possible also by that pistol. Gunshot ହେଇଛି ବୋଲି କହିଛି. Gunshot ଇଏଟା siege ହେଇଥିଲା.
That has been seized.
And it was not produced before this gentleman, the doctor.
That has not mentioned, my lord.
But are you sure that the pistol or the gun has been seized?
My lord.
What is that ammo material? It was produced before during trial also. Yes, MO1 is that gun.
My lord.
So MO1 is the gun. It was seized from which position or when it was seized?
Man, the other persons, my lord, those are control the victim. They kept the gun, my lord.
Okay,
The
so at the spot,
at the
the
spot,
gun was seized.
my lord.
That is also the evidence of the IO.
My lord.
Let us say IO or evidence.
There are two PW 9 and 10, my lord.
No, see you gun ta je siege karthala.
PW 10.
10.
10. So what he has stated about the seizure of the gun?
Para 3. Para 3 of PW 10. On the same day at about 8 p.m., I visited the spot. That is SP near the village Redra on the bank river of Sanko and found the dead body of the Nathakisan lying there and a cotton bag were also lying there and the cooking materials, namely the food was
On the same day মানে যদি না date of lodging of the affair তার মানে 16 ହଁ ତାରେ 16/4/1999 ଦିନ FIR ହେଲା ସେଇଦିନ ମଧ୍ୟ ଗନ୍ ଟା ସିଜ୍ ହେଇଗଲା ଯୋଉ ଗନ୍ ଟା କି ପ୍ରଡ୍ୟୁସ ହଉଛି ଟ୍ରାଏଲ ବେଳେ ମାର୍କଡ as MO1. Why it was not produced before the doctor who conducted post-mortem examination, and why it was not sent for ballistic examination? Because you must have you received the pellets? And
ballistic report is there.
Where is that?
That is 68, page 68.
60?
68.
68.
My lord.
One country made gone so and so. Working condition capable of discharging projectiles. So this is the firearm defined under substance. Okay. Chemical agents in the barrel so and so revealed the presence of gunpowder residues showing that the gun has been used for firing. The exhibits marked as C1 to C11 would have pellet aluminum caps, and they can be used as cap for preparing the percussion caps, which are usually used in so like so on. The exhibits marked as so are 32 numbers of lead pellets as revealed by chemical examination and usually used at so and short change in the recorded reloaded cartridge. The exhibit so is containing an explosive mixture and usually used in preparation. So that means the gun was seized from this one and it was also sent for ballistic experts opinion, and pellets were also seized and it was also sent, and he has given a positive reply that it was in working condition, number one. Then it comes within the definition of Arms Act. Then gunpowder was also found there. Then the pellets also he has given the opinion. So that part is there, and it was also the gun was produced before this one. So now
the very important PW 3 evidence, my lord.
But where is the material, Mr. Tripathi, that the pellets which were sent to the ballistic expert for opinion along with the gun, those are also used in firing at the deceased? ତା ଧିରେ ଯୋଉ ଇଞ୍ଜୁରି ଗୁଡାକ କଜ ହେଇଛି ଡିସିଜ୍ଡ ସେଇ ଯୋଉ ପର୍ଟିକୁଲାର ପିଲେଟ ରେ ଆଧିରୁ ଯୋଉ ପିଲେଟ ଫାୟାର ସେଇଥିରେ ହବ ବୋଲି ଆପଣ କୋଉଠୁ ଇଏ କଲେ? ଆପଣ ଯଦି ସେ ପିଲେଟ ମନେ କରନ୍ତୁ ତା ବଡିରୁ ରିକଭରି ହେଇଥାନ୍ତା, ଇଟ୍ସ ଏ ମ୍ୟାଟର ଡିଫରେଣ୍ଟ। ଅର୍ ସେ ପିଲେଟଟା କୋଉଠୁ ପାଇଲେ ଆପଣ? ସେ ଯୋଉ 30ଟା ପିଲେଟ ପଟେଇଲେ ଏଟା କୋଉଠୁ ପାଇଲେ ସେ ବିଷୟରେ?
There is an exit wound also. Then where from you got it?
এইଗୁଡାକ ବାହାରି ଯାଇଛି ନା, ଯଦି ବାହାରି ଯାଇଛି ମାନେ ଆପଣ ବାହାରେ କୋଉଠୁ ପାଇଥିବେ, ଆଉ ବଡି ଭିତରେ ଥିଲେ ବଡିରୁ ପାଇଥାନ୍ତେ। ତେଣୁ ଏଇ ଯୋଉ ପିଲେଟ ଗୁଡାକ ଆପଣ ପଠେଇଛନ୍ତି, ଯଦି ବଡି ଭିତରେ ଅଛି ଓକେ, ବଡି ଭିତରୁ ଆପଣ, କାରଣ ଏଇ ଯୋଉ ଡକ୍ଟର ଆପଣ ଦେଖନ୍ତୁ ତାର ଏଭିଡେନ୍ସ ରେ ସେ କିଛି କହୁନି ଯେ କୌଣସି ପିଲେଟ ସେ ବଡି ଭିତରୁ କିଛି ପାଇଲା ବୋଲି। ତେଣୁ ତାମାନେ ଚାନ୍ସ ନାହିଁ ଯେ ସେଠିକି ପଠେଇବା କଥା। ମାନେ ସେଇ ପିଲେଟ ଯଦି ରିକଭରି ହେଇଥାନ୍ତା ତାହେଲେ ତାକୁ ଗନ୍ ସହିତ ପଠେଇ ଦେଇଥିଲେ ସେମାନେ କହିପାରିଥାନ୍ତେ ଯେ ହଁ ଏଇ ଯୋଉ ପିଲେଟଟା ଆଧିରୁ ଆ ବଡି ଭିତରୁ ମିଳିଲା, that was used or from this particular gun, ସେଟା ଗୋଟେ ଲିଙ୍କ କରିଥାନ୍ତା।
You have recovery blank cartridge? No.
ସେଗୁଡାକ କୁଆଡେ ଗଲା? ଦ୍ୱିତୀୟ କଥା ହଉଛି ଆପଣଙ୍କର ସିଏ ଯାହା କରିକିନି କହୁଛି doctor that gunshot was made at a distance ranging from 1 to 2 meter. 1 to 2 meter ମାନେ ଧର ସେଇଠି ହେଲା ଆମେ ଏତିକି ଭିତରେ ହେଲା, ଏତିକି ଡିଷ୍ଟାନ୍ସ ଭିତରେ ହବ। ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆସୁଛି କିନ୍ତୁ ଯେ 30 ମିଟର ବୋଧେ ଅଛି ନା କଣ?
As per FIR, but at page 51, same doctor in the cross-examination, all the injuries are possible by one gunshot. I have not mentioned about the gunshot distance in my report. What 51, page 51. Further cross-examination.
All the injuries are possible by one gunshot. I have
not mentioned about the gunshot distance in my report.
In my report. This is cross.
ଠିକ ଅଛି, କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ଆପଣ ଆଣିଲେ, ଏଟା ପଚାରିବାର ନଥିଲା, ଆପଣ ପଚାରିଛନ୍ତି ସେ ଯାହା ବି ହଉ, କିନ୍ତୁ ଚିଫ ଏକ୍ସାମିନେସନ ରେ ଯୋଉ ଆପଣ ଯଦି ଓରାଲ ଏଭିଡେନ୍ସ ଆସିସାଇଲାଣି ଯେ ରେଞ୍ଜ ଟା ହଉଛି ଆପଣଙ୍କର 30 ମିଟର ରେ ଅଛି,
As per FIR,
30 ଫୁଟ ମାନେ କେତେ ହବ କି ଆପଣଙ୍କର?
10 meters.
ହଁ 10 ମିଟର। ଆପଣଙ୍କର ଯଦି କ୍ଲୋଜ ରେଞ୍ଜ ରୁ ଫାୟାର ହବ ନା, ତାର ସେଠି ଗୋଟେ ବ୍ଲାକେନିଂ ହବ, ଯୋଉଟା ଯୋଉଥିରୁ ସେମାନେ ଜାଣିପାରନ୍ତି that is the way to detect that କେତେ ଅଛି, ସେଇଥିରୁ ଜଣା ପଡିବ ଯେ ଏଇ ପର୍ଟିକୁଲାର ଗନ୍ ଟା କେତେ ଦୂରରୁ ବ୍ୟବହାର ହେଇଥିବ। ତେଣୁ ଆପଣଙ୍କର that is in their Modi's jurisprudence also there। ତେଣୁ ସିଏ ଯେତେବେଳେ ଡକ୍ଟର କହୁଛନ୍ତି ଆପଣଙ୍କର your witness and in the chief examination that the gunshot was made at a distance ranging from 1 to 2 meters, and your witnesses have stated that the gunshot was fired from a range of 30 meters. FIR ଅଛି ନା 30 ମିଟର?
30 ମିଟର FIR।
କୋଉଠି ଦେଖେଇଲା ଆଉ ଥରେ ପଢିଲେ ସେଟା?
FIR at page 23 my lord, paper 23 ପାଖକୁ ମହାଦେବ କିଷାନ ଉକ୍ତ ଅବସ୍ଥାରେ ଆସି ପ୍ରାୟ 30 ଫୁଟ ଦୂରରେ ଠିଆ ହୋଇ ଶୁକ୍ରୁ କିଷାନକୁ ମାରିଦେଇ ବୋଲି ଧମକ ଦେଲା। ଏହା ଦେଖି ମୋର ବାପା ନାଥ କିଷାନ ଖାଇ ବସିଥିବା ଜାଗାରେ ଠିଆ ହୋଇ ମହାଦେବ କିଷାନକୁ ବୁଝାଇବାକୁ ଚେଷ୍ଟା କରିବାରୁ କିନ୍ତୁ ମହାଦେବ କିଷାନ ରାଗି ଯାଇ ମୋର ବାପା ନାଥ କିଷାନକୁ ଟର୍ନ କରି ସେ ମହାଦେବ କିଷାନଙ୍କୁ ଧରିଥିବା ବନ୍ଧୁକରେ ଗୁଳି ଫୁଟାଇଲା।
ଷ୍ଟେଟମେଣ୍ଟ ରେ କିଛି ଏଭିଡେନ୍ସ ରେ ଅଛି ପ୍ରାୟ ଏଭରେଜ କେତେ ଡିଷ୍ଟାନ୍ସ ରେ ସେମାନେ ଥିଲେ?
ଏଭିଡେନ୍ସ ରେ
PW1 ଦେଖନ୍ତୁ, PW1 is the author of this FIR. Now let's see PW1. One is
not stated about the distance. This is Natha Kisan is my father. I accuse Mahadev Kisan is my co-villager. I know him. The occurrence took place at 12 o'clock in the noon, 2 years back in the summer season. Ganapati Kisan is my younger brother. Myself, my father and my brother were living in joint mess. Ganapati Kisan had killed an ox. For that reason, he was hosting a feast on the bank of a river Sankha at the relevant time of occurrence. About 30 to 35% of our caste were present in the feast. We all are sitting to take our meal. At that time, accused Mahadev Kisan raised commotion on the issue of a serving of meat curry to him. Shukr Kisan, elder brother of father of Mahadev, intervened and tried to dissuade accused Mahadev Kisan from his indulgence of quarreling for nothing. There is a hot exchange of words between Shukr Kisan and Mahadev Kisan. Mahadev Kisan left the spot of the feast and returned there after some time with a gun. He threatened Shukr Kisan to fire at him. Shukr Kisan ran and took shelter behind the back of my father Natha Kisan. My father Natha Kisan tried to pacify the accused Mahadev Kisan without paying heed to the words of my father. Accused Mahadev Kisan fired at Shukr Kisan. The bullets hit right side chest of my father and he fell down on the ground and died instantly instantly. The persons present there overpowered the accused Mahadev Kisan and kept him in captivity till arrival of police. Myself, Vishnu Kisan and Parameshwar Kisan went to the PS. I lodged the oral report in the PS. The report was reduced in writing by the police Babu. The report was read over and explained to me, and after understanding the content of the thereof, I put my LTI on the report. Immediately after lodging the FIR, police came to the spot and held inquest over the dead body of Natha Kisan in my presence. Vishnu Kisan and Parameshwar Kisan were present at the time of occurrence along with other fellow caste man. MO1 is the gun. Seal of gun was open in the court in order to comfort the same to the witness. Cross-examination.
Vishnu Kisan is PW?
Vishnu Kisan, my lord. Seven.
Vishnu Kisan P2. PW.
My lord. Cross-examination. I cannot say from where accused Mahadev Kisan got the gun. I had not seen the gun MO1 prior to the occurrence. I had not seen the accused moving with it or using the gun prior to the occurrence. I had also no knowledge. I had also no knowledge that accused Mahadev Kisan is possessing a gun. Gauntia of our village is having a gun and he is having a license for possession of that gun. Ganga Pradhan is the Gauntia of our village. He knows how to use the gun. I do not know how to use the gun. The accused also does not know how to use a gun. The PS is at a distance of 2 kilometers from the spot. Police Babu seized the gun at the spot on production of by Vishnu Kisan, PW2. Mahadeva was also invited to the feast. It is not a fact that as my fellow caste men were inimically disposed towards the accused, he was not invited to the feast. It is a fact that accused came to the spot of the feast and a quarrel on the issue as to why he was not called to the feast, as he has also a right to take meat curry in the feast. It is a fact that Shukr Kisan intervened to dissuade the accused and there was a hot exchange of words between them. I also got annoyed as the accused unnecessarily started to spoil the feast. I cannot say whether the gun belongs to a hunter and that the hunter had concealed the gun in the jungle near the venue of the feast and that my father had knowledge about the place of concealment of the gun, and that when accused Mahadev Kisan quarreled unnecessarily, my father brought out the gun from the place of concealment and tried to terrify the accused by showing the gun to him, and that none of us had knowledge that the gun is loaded and that the accused tried to snatch away the gun from my father, leading to tussle between my father and accused. Shukr accused and Shukru Kisan, and that in a process the pellets went up to hit my fathers as well as the accused. It is not a fact that the accused got injured by pellets at the time of occurrence. It is a fact. It is not a fact that as my father died of gunshot injuries, all my fellow castmen, including me, left the venue of the feast in a terrified state, kept the matter secret for about 4 days, and thereafter police came to the village on getting information from somewhere, and during inquiry by the police, we falsely implicated accused Mahadev Kisan. It is not a fact that all the accused present in the feast were detained in the PS for about 4 days. It is not a fact that I have lodged the report as instructed by the police, and I am deposing falsehood in connivance with my fellow castmen. It is not a fact that the death of my father was accidental in nature, and that the accused not fire the pellets at him or Shukru Kisan. In Pidol 2,
So, as it appears, from front to front, the fire has been made. It was on the right side chest, as it appears from the evidence of PW1, that my father tried to pacify. That is in page number 32 of PW1's evidence. Without paying any heed to the words of my father, accused Mahadev Kishan fired at so. So it is front to front, and the bullet hit on the right side chest of my father, and he fell down.
One thing here, Secretary Mallard, when my father Natho Kisan tried to specify accused Mahadev Kisan without paying heed to the word of my father, accused Mahadev Kisan fired at Shukru Kisan. The bullet hits the right side chest of my father.
Yes,
my lord. And thereafter, my lord.
What have you elicited in the cross-examination of this particular witness? Let us say that we are focusing now on PW1.
My lord.
He is an eyewitness, and he has stated how the occurrence has taken place, and how the appellant left the spot, came with a gun, and face to face he fired gunshot at the
Shukru Kisan, not the my lord Natho Kisan, my lord. That is the my lord case, my lord.
No,
his intention to kill Shukru Kisan, my lord.
It's a transfer of malice, that is 301. That is also,
my lord.
If you want to kill X,
my lord.
And in that process Y is also killed, same intention can be gathered. So that is not the thing.
My lord.
So a question is that Shukru Kishan, suppose you want to fire, and Shukru Kisan ran and took shelter behind
back of my father. But this story, my lord, a new story, my lord, he developed, my lord. In the affair, he has not stated like this, my lord. Subsequently, he 161 statement developed this story. That is my father, the Shukru Kisan shelter behind the back of my father.
301 of the Indian Penal Code. What is the name?
Yes.
Please read it out. 301.
Culpable homicide by causing death of a person other than persons whose death was intended. If a person, by doing anything which he intends or knows to be likely to cause death, commit culpable homicide by causing death of any person whose death he neither intends nor knows himself to be likely to cause. The culpable homicide committed by the offender is of the description of which it would have been if he had caused the death of a person whose death he intended or knew himself to be likely to cause.
ତେଣୁ ତାକୁ ଧରାଯିବ ଯେ ଆପଣ ତାରି ହିଁ ତାକୁ ମଧ୍ୟ ମାରିବାକୁ ଇଣ୍ଟେନସନ ଥିଲା ଯଦି ତାରି ପ୍ରୋସେସ ରେ ଏବଂ ଆପଣ ଜାଣିଥିଲେ ଯେ ତାର ଡେଥ ହବ ବୋଲି ଯଦିଓ so this is called transfer of malice.
Okay. To that respect, my lord, we told three, my lord, evidence is very important, my lord. Sukru Kisan, my lord.
You see, in bullet cases,
My lord,
when eyewitnesses are there, usually the only way out is that whether you have to bring it out the distance factor,
my lord,
first of all. And once you found that the doctor is stating that from this close range it is possible, that means from 1 to 2 meters it is possible. So the endeavor should be by putting some questions, maybe by leading questions, that the distance between the assailant and the deceased was more, so that you can say that at such a distance it could not have been possible to cause such injury. That is the only way out.
My submission before urging, my lord, it is coming under the section 300, exception 4, my lord. Exception 4, my lord. Section 300, exception 4, my lord.
So you have to, first of all, you argue on this aspect, whether you have found out or anybody has stated about the distance factor.
My lord. But PW 3, my lord. PW 2 also, my lord. First page, last 3 line also. Just you read it. Last 3 lines. Sukru Kisan went to hide himself behind the back of the Natha Kisan, and Natha Kisan tried to pacify the accused Mahadev, but in vain. Accused Mahadev fired the gun, aiming at Sukru. The bullet hit right side chest of Natha Kisan, and he died there. My lord. But the PW 3, my lord.
What that 301 says, suppose you are not intending to kill X, you are intending to kill Y, but while you are firing, in place of X, Y is hurt. You intended to kill X, but in that process Y was hurt and Y received the injury and Y died. Then it will be hold, or it will be as per 301, that as if you are intending to cause the death of Y, okay, or knew that the death of Y will be caused. So that is transfer of malice, even though you have not intended to.
But
so once you say that there was a sudden quarrel, but again you see that what is your conduct at this spot. It's not that that gun was available at that place, or you just picked up that gun from somewhere and fired. You had gone to your own house, brought that gun with you. So just think of this situation. Quarrel is all right, but the moment you go somewhere,
my lord, the entire intention and premeditation of mind, my lord, to kill my lord Sukru Kisan, not the Natha Kisan, my lord.
No, that's you see what exception 4 says, that during the course of sudden quarrel, so without any premeditation, if you do something, okay, without any intention, or so that would be that would come under that exception 4.
Culpable homicide, not murder.
Yeah.
If it is committed without premeditation.
Right.
He predetermined to commit murder of Sukru Kisan.
Premeditation, no, that would come 301. But premeditation, how can you say that? Suppose
in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offenders having taken undue advantage or acted in a cruel or unusual manner.
No, the moment it to have reacted then and there, matter is something different. But once you go to your house, bring the gun with you. That shows that that intention is there. You are coming prepared. You are coming prepared to commit that. It's not that something was lying there, or you had already that weapon with you. So that is the basic difference.
The entire intention, my lord, to kill Sukru Kisan.
That you will not only once you go to 301, that argument will not sustain. There are number of decisions on that. this particular point you say, you try to find out some decisions that suppose somebody during course of quarrel left that place and he went to his house, brought any weapon and then assaulted, maybe a single blow or some, and in that case it has been hold that no, leaving that place is there. That is most important. You may find also some decisions that the accused left the spot and he came back after some time with the weapon and then assaulted. There also it is stated that the situation was such that that was there in the mind. That means he was so much the situation aggravated and his mind was preoccupied with that. So in that way he has just reacted. It may be that it was not lying, it was there somewhere else. So find out a decision where the appellant left the spot, okay, went to his house or somewhere and picked up okay, so that would be a case here, because the case is that you left the spot, went to your house, brought the gun. So that means you come prepared to the spot.
Your intention was very clear.
Clear to commit murder for Sukru, my lord. Not that is my
order.
I know, my lord. The 301 is very clear, my lord. Your lordship rightly, my lord, pointed out that, my lord. But in fact, I will got decision, my lord.
At least some materials are there,
My lord.
and find out a case of gunshot, not this axe, etc. It's a gunshot at the chest, right chest, corresponding injuries are there. So in such a circumstance, whether 304 part 2 or part 1 would be attracted or not. Find out a case. You can find out from Manu Patra. Gunshot injury 302, 304 part 2. You may get it. Not this axe, this lathi, etc. Focus on a gun case. Okay. Gun case, will take up this matter tomorrow because it is time. Find out a decision. No, no.
Week be ଅଛି interview ki ଅଛି.
এটা
interview
week ଅଛି
ମାନେ tomorrow
ଆପଣ
ଦେଖି ଦଉ ଯାଇ.
it will not take much time. I am hinting at you that you search for Manu Patra, you will get, just type it out, 302 304 gunshot injury, you will find decisions. And also to your satisfaction also you search for 301, you will find that similar cases are there. He was not intending to kill X. This man suddenly came in between. In such a situation, whether it would be 302 or any lesser offense, that also you found for your satisfaction, because section is very clear that it is a transfer of malice and same intention would be there. Okay. So we'll take up this matter tomorrow. Okay. Bye.
My lord's pardon to mention that
and IN number 2120 of 2022 respectively. Grant counsel for the state submits. Verify whether the copy is available with you or not. Otherwise, there is an IA for modification of that order. So that IA number is 2067 of 2020. Yes, so you obtain instruction on that. He says that about his financial difficulty, this, that. So you have just obtain instruction through that IAC. Okay. IAC तो देखिए लिखी देवे है ना. and a free copy of the order be handed over to the learned counsel for this. Okay.
Lordship fixes a date.
It will come on 25th September of the.
Lordship, she has to deposit on 20th. So can it be prior to
No,
that?
you this time you do it, then yes, next.
Obliged.
My lord, I may be able to make a mention out of the list, your lordship. This is a matter of before your lordship on 18/5/2023, last occasion. Your lordship has specifically argued to after entering of summer vacation, your lordship. Thereafter,
All right, please give it.
My lord, I may be pardoned to mention, my lord, from the list, item 139, my lord.
139
item,
Yeah.
my lord, for interim bail. Last time, your lordship directed state council to obtain instruction regarding his mother's illness from the.
Okay. Bring that file, we'll see. I'm taking.
My lord, when it will be taken, my lord?
Just let him bring the file, we'll take all this. Yeah.
Tied up there for withdrawal. Withdrawal.
Give it. A tied up on withdrawal ପାଇଁ କହୁଛନ୍ତି ନେଇ ଆସ କାଲି.
Office banner.
Yeah.
Mercy, pardon, my lordship. Initially, I have mentioned that item 235 that tomorrow, not item 235, my lordship.
No, he is just calling for that file. We'll take up this one.
My lordship, whether instruction is not.
Yeah.
PID case.
Please use the mic properly. Yes.
OPID case, lordship. Lordship on mention, lordship stated that it would come on 5th or 8th. It is not in the list.
Please file a memo to see that it is listed next. Yeah.
Weekly list item number 1.
Item 1, may I please your lordship? Your lordship, the present appellants have been charged and convicted under section 323, 324, 325, 307 and 34 of IPC. Your lordship, in the present case, there were 15 number of accused, out of which these 2 petitioners have been convicted.
Others were acquitted.
Yes.
What is the relevant operative part of the judgment?
Page 85.
85. So, okay, 6 months, 1 year, then 2 year, 2003, 3 years, 307, 5,000, okay, concurrently. So the maximum one is 3 years, right? You were on bail during trial.
Yes, your lordship.
Okay. What is your name?
Ramesh Kumbhar.
What is your name? Yes.
Show me das.
Kagaz diyo. Admit he was on bail granted, stay realization of fine. Yes.
Item 2.
Please, your lords. The appellant is convicted under section 32, 13(1)(d) of the PC Act and under section 7 of the Act, my lord. And he is sentenced to undergo imprisonment for 2 years.
Page, relevant page, start.
65, my lord, operate. 55. Internal page 55 and
65, okay. 1 year, 2000. Then under 2 years, 5,000, 24 to perform. So, it is not mentioned whether it is concurrently, okay. So the maximum one is 2 years, no?
my lord.
2 years.
2 years and 5.
You were on bail during trial?
My lord.
Yes, Mr. Da.
I will file my appearance by the end of October, madam.
All right, admit, bail granted, stay realization of fine. Mr. Das submits that he'll file the appearance memo by October 31st. name shall be reflected. Free copy of the order be handed over to. Yes, next.
Item 3.
Pardon to mention, my lord, I am on GC, my lord.
Yeah.
The appellant has been convicted under Section 7 of PC Act RI for 2 years with fine 10,000 along with
Page number, what is the operative part of it?
59 is operative portion of order, my lord, last paragraph. 59.
Okay.
59.
59 last sentence, 60 continuing.
Okay.
59 last sentence.
2 years.
My lord, it continues. 60.
10,000. Okay, 7. Then RI for 2 years, 10,000, 13 so on so concurrently. So it's 2 years.
Concurrently, my lord.
You are on bail during trial?
Yes, my lord. I am on bail during trial.
Yes, Mr. Da.
I have already filed my appearance on 8th of this month. 8/9/2020.
Mr. Sanjay Kumar Das, Land and Standing Counsel for the Vigilance Department, submits that he has already filed the appearance memo on 8th of September 2023. Let the registry place the same on record. Admit he was on bail, bail granted, stay realization of fine. Free copy of the order be handed over to Mr. Das. Yes, next.
Item 4.
Yes, Mr. Panda.
Please, your lordship. Lord Chair, I am in custody since 11th of January 2021.
You supplied the deposition copy, I
Yes,
think.
yes.
All right. Is it the first time it is coming?
This is second time.
So earlier application
That is 310 of 2021. Your lordship rejected it on 5/9.
Where is that order?
Oh, I'm sorry. That relates to the co-accused. So this must be the first.
Sarojin, okay. So this is PRLA 312 of 2022. So custody date is
11th of January 2021.
and charge sheet under section
302-201 read with 34 IPC and 32 small v of the SC and ST POA.
32B.
Mallards.
Notice sufficient?
Yes, notice sufficient, Mr. Kuntia.
So name of the deceased?
Name of the deceased is Puja Sethi.
This petitioner is a lady appellant.
Yes.
Any relationship between the petitioner?
No relationship. It appears that the deceased was staying with this petitioner and the co-accused. That is the prosecution case.
Okay. So date of occurrence is?
Lords, on 3/12/2020, a dead body was found lying in a field, Millards. And a FIR against unknown persons was registered.
Who lost the affair?
That is one Rasananda Malik, Millards.
Who is he?
He is the Rasananda is SI of Jagannath Prasad PS. The original informant is one Sudhakar Misra of Bidipur. He lost the information on 2/12/2020 that a dead body was found lying in a paddy field near the village, Millards. And that led to registration of UD case 15.
Okay.
Thereafter, Millards, the SI who was inquiring into the UD case, Rasananda Malik of Jagannath Prasad PS, he lost the affair to the effect that the body was found to have strangulation marks, Millards. And therefore, it was registered as...
After postmortem, it was found to be a case of strangulation.
It was found to be a case of strangulation.
Now, what material came during course of investigation?
During course of investigation, my lords, a telephone numbers were recovered, which led to some people being examined who were acquaintances of the deceased. They disclosed the names of the petitioner and the other co-accused, my lords. And the other co-accused has made a confessional statement.
What is the name of the co-accused?
His name, my lords, is Manas Kumar Sahu.
Manas Sahu.
Paik Rai.
Manas Paik Rai. Okay.
Manas Ranjan Paik Rai.
Okay, yes, that co-accused, what he did?
He made a confessional statement before three of these witnesses, that is Basanta Bag, Jyotiranjan Muduli and Vanita Sahu, that he and this lady, they have together committed the murder of the deceased.
That was not in presence of police?
No.
Okay.
And he also led to recovery.
Recovery of what?
Recovery, my lords, of the vehicle which was used, my lords, for committing the offense, for throwing the body, disposing of the body.
What was that vehicle?
One Chevrolet Beat car.
Car.
Yes. OD 33M 3014.
No, in what way they committed murder as per the extrajudicial confession?
That at 3:30 p.m. out of anger, the male accused gave a kick in the belly of the deceased, and this appellant assaulted her, pressed her neck with a nylon sari, and she died due to asphyxia.
Okay. So that is one evidence, extrajudicial confession
that is the only material, no other.
At your instance or anything like that? And last scene?
No, last scene, my lords, that there is an evidence of the house owner where we were staying, that she was living with us. That's all.
House owner, what is his name?
His name is one Vijay Sahu.
What he has stated, who was staying this?
He stated that the deceased was staying and working as a domestic help with this appellant and the male accused, Manas Paik.
What is the relationship between this petitioner or appellant with that Manas?
They are just live-in relations.
Okay. What is the age of that deceased, Pooja Sethi?
25 years.
And now the trial has commenced?
Yes, 6 witnesses have been examined.
What they have stated?
My lords, out of the 6 witnesses, my lords, PW1 is the doctor.
7, I think 7 witnesses have been examined.
Yes, 7 witnesses.
Yeah.
The only witness who has stated is PW6 is the only relevant witness, my lords, who has stated like this, that he knows both the accused and the deceased. He says that Shibani was working in a showroom in Market Building, Bhubaneswar, named Gita Fashion. I used to meet her when I came to Bhubaneswar. Shibani introduced me to Pooja Sethi. Pooja told over telephone that she was staying with the accused. She told that they were ill-treating her and were insisting her for prostitution. In November, Pooja called over phone, told the accused were assaulting her, requested me to take her while she was in Market Building, Bhubaneswar. In December, when Pooja could not be contacted over phone, again I telephoned to accused Manas, who told me that he and Sarojini had killed Pooja.
Okay. Yes, Mr. Tripathi?
Yes, please.
So it's a case based on circumstantial evidence?
Yes, that's true.
These are the circumstances or anything else?
The statement of Basanta Kumar Bag, 164 statement.
Basanta Kumar Bag.
Yes, ମୁଁ ପୂଜାକୁ ଅକ୍ଟୋବର ମାସ ଶେଷ ଆଡକୁ ଚିହ୍ନିଥିଲି। ଆମର ମାର୍କେଟ ବିଲ୍ଡିଂ ରେ ଦେଖା ହଉଥିଲା। ସେତେବେଳେ ପୂଜା ତାର ଫୋନ ନମ୍ବର ମତେ ଦେଇଥିଲା। ମୁଁ ଫୋନ କରି
କଥା ହଉଥିଲି। ନଭେମ୍ବର 28 ତାରିଖ ଦିନ ଆମେ ମାର୍କେଟ ବିଲ୍ଡିଂରେ ଦେଖା ହେଲା ପରେ ଆଇଜି ପାର୍କରେ ବୁଲାବୁଲି କରି 4:30ରେ ପୂଜା ପଳେଇଲା। ପୂଜା ମତେ କହିଥିଲା ସେ ପାଣ୍ଡରା ଛକରେ ରହୁଛି ବୋଲି, ସେ ମତେ କହୁଥିଲା ସେ ତା ଭାଇ ଭାଉଜଙ୍କ ପାଖରେ ରହୁଛି ବୋଲି, ଓ ସେମାନେ ତାକୁ ବେଶ୍ୟା କାମରେ ଲଗଉଥିଲେ ଓ ଖାଇବାକୁ ପିଇବା ଦଉନଥିଲେ ଓ ମାଡ଼ ମଧ୍ୟ ମାରୁଥିଲେ। ନଭେମ୍ବର 30 ତାରିଖ ସକାଳ 6:30 ମଧ୍ୟରେ ପୂଜା ମତେ ଫୋନ କଲା। ସକାଳ 8:30ରେ ପୂଜା ପାଖକୁ ରାଜମହଲ ଛକ ପାଖକୁ ଗଲି। ସେଠାରେ ମାର୍କେଟ ବିଲ୍ଡିଂ ତାପରେ ଆଇଜି ପାର୍କରେ ବୁଲାବୁଲି କରି ମୁଁ ପୂଜାର ମାନସ ଭାଇଙ୍କୁ ଫୋନ କରି ପୂଜାକୁ ଲିଙ୍ଗରାଜ ମନ୍ଦିର ପାଖରେ ଛାଡ଼ିଦେଲି। ତାପରେ ସେଦିନ ସନ୍ଧ୍ୟାରେ ମୁଁ ସାରଳା ବସରେ ଘରକୁ ପଳେଇଲି। ସକାଳେ ଘରେ ପହଞ୍ଚିବା ପରେ 10ଟାରେ ମୁଁ ତାକୁ ଫୋନ କଲି, କିନ୍ତୁ ତାର ଫୋନ ସୁଇଚ ଅଫ୍ ଦେଖେଇଲା। 2 ଦିନ ପରେ ପୂଜାର ମାନସ ଭାଇ ମତେ ଫୋନ କଲେ, ପଚାରିଲେ ପୂଜା ତୁମ ପାଖରେ ଅଛି କି? ମୁଁ କହିଲି ଭାଇ ମୁଁ ତୁମ ପାଖରେ ତାକୁ ଛାଡିକି ଆଇଲି, ମତେ କଣ ପଚାରୁଛ? ତାପରେ ସେ କହିଲେ ପୂଜା ଆଉ ଦିଶୁ ନାହିଁ। ତାପରେ କହିଲେ ପୂଜାକୁ ମାରୁ ମାରୁ ଆମେ ମାରିଦେଲୁ। ମତେ ଧମକେଇ କହିଲେ ଏ କଥା କାହାକୁ କହିବୁନି।
ସେଇଟା ତ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ।
And the last scene theory of that house owner.
They were staying together.
No, they are left that building together.
When?
That night. And came back with only 2 persons.
No. Please, who is that owner that you said?
S.K.SAHOO.
Please read that.
Yes, yes, madam. मोर ना विजय कुमार साहू। मु गोटे 2 महला कोठा करिछि। ऊपर महलारे रहे, तळ महलाटी भड़ा लागिछि। गत 1 वर्ष हेबो मानस रंजू पाइकरे आउ तांको स्त्री सरोजिनी ओ तांको सांगर झियो रहे। मानस बाबू गाड़ी चलती और तांकर गोटे बीट गाड़ी थिला जार नंबर 100 अटे। से घरे प्राय रुहंतिनी, मझिरे मझिरे कुआडे बुली जाती। सेमाने से झियो को बहुत मारपीट करती। मु बहुत थर मध्य तांको मना करिथिली, किंतु सेमाने मो कथा सुनंती नाही। एपरि कि से झियो को सबुबेले काम करांती, किंतु ठीक रे खाइबा को दियंती नाही। से झियो बहुत थर तांको पक्षरु तांको पाखरु पळेई जिबा पई चेष्टा करिछि, किंतु सेमाने ताको छाड़ंती नाही। सेमाने पचारिबा से तांको झियो बोली कुहंती ओ ता नाम पूजा बोली कहंती। से मासको मास पैसा ठीक समय दियंती। तेणु मु तांको सहित एते कथा हबार नथाई। गत नवेम्बर 30 तारिख राति प्राय 11टा पाखापाखि हेबो सेमाने घरु कौन सबू जिनस पत्र नहीं गाड़ी रे लोड कले। मानस सरोजिनी उभय मिसी कुआडे गले मु जानिनी, किंतु सेमाने 3 दिन पर सेटाको आसिले। से झियोटी किंतु तांको संगरे नथिला।
कौन है?
से झियोटी किंतु सेमानक संगते नथिला।
गोटे लाइन पूर्व पढन
कुआडे गले मु जानिनी,
ना आउटे पूर्व
गत 30 तारिख राति रे 11टा पाखापाखि हेबो सेमाने घरु कौन सबू जिनस सबू नहीं गाड़ी रे लोड कले ओ मानस सरोजिनी उभय मिसी कुआडे गले मु जानिनी।
ताले से झियो गला बोली कोड कहू
ना कहली मु जानिनी, किंतु सेमान 3 दिन पर
लास्ट सीन केम दि आपण आनी बेटा झियो तो मूल नथिला। लास्ट सीन कोड आसी
क्लियरली से कहिछि से झियो तांको सहित नथिला।
ता परटा पड़ दिछि पूरा फुट। मु सेमाने पचली झियो कोडे गला बोली, सेमाने कहले झियो बाकी कला पत्र जाइछि परे आसी।
ठीक अछि। से झियो को देखिबा जो आपण कहउछन सेटा नथिला। यस मिस्टर खुंटिया, व्हाट डू यू से?
Investigation revealed, my lord, the deceased was with the petitioner family, my lord, and they are using it for the prostitution, and the collected money, huge amount of money.
Where?
At Bhubaneswar.
No. Which place they were utilizing it may be a hotel or any
they are using the
सेमती कोन आसिले आसीओ कि आपण कोठी तांकू लगौथिले, को माने तार कस्टमर थिले, तांकू ये करथिले, एगुडा को नहले आ खाली गोटे लाइन कह देल हबो कि प्रोस्टिट्यूशन लगौथिले। Are the Land Council for the petition, appellant Land Council for the state, and Land Council for the informant. Land Council for the appellant submitted that the appellant is in judicial custody since 11/1/2021, and she has been charge sheeted under section 302(201) by 34 of the Indian Penal Code.
And
section
32B of the SC.
32B of the SC/ST/PO Act. He further submitted that the one Sudhakar Mishra of Bidepur lodged a report on 2/12/2020 morning to have noticed a dead body lying on the paddy field of one Dhonu Naik in the village Bhusandapara. And accordingly, the Jagannath Prasad UD case was registered. And Jagannath Prasad police station, and on dated 15 of 2020. And during course of the inquiry of the UD case, the dead body was sent for post-mortem examination, and it was found that the cause of death of the deceased was on account of strangulation, and accordingly, R.N. Malik, SI of Police Jagannath Prasad Police Station, lodged the first information report on his own information, and accordingly the case was registered. The Land Council further submits that the case is based on circumstantial evidence and except the confessional statement of co-accused Manas Ranjan Paik before some persons, there is no other clinching material available on record against the petitioner. And in the meantime, trial has commenced and 7 witnesses have been examined. But during trial also, so far no clinching evidence has come against the petitioner. And therefore, the bail application of the petitioner may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and placed the statement 164 CRPC statement of one Basant Kumar Bagh, who stated about the extrajudicial confession made by the co-accused Manas Ranjan Paik. He also placed the statement of house owner Vijay Sahu, where the deceased was allegedly staying with the petitioner and co-accused Manas Ranjan Paik. Though the Land Council for the state submitted that the statement relates to last seen of the deceased in the company of the appellant as well as the co-accused. But on going through the statement, it appears that the said witness has not stated that while leaving the house, the appellant, the deceased was also in the company of the appellant and co-accused Manas Ranjan Paik. The Land Council for the state, informant opposed the prayer for bail and submitted that from the case diary it reveals that the appellant and the co-accused were engaging the deceased in prostitution and collecting money, and they were also assaulting the deceased. Considering the submission made by the Land Council for the respective parties, absence of any direct evidence, nature of circumstantial evidence appearing on record, progress of trial so far, period of detention of the petitioner in judicial custody, and keeping in view the proviso to section 437(1) CRPC, I am inclined to release the appellant on bail. Allowed shall appear before the trial court on each date, and the case would be posted for trial.
Published. Urgent copy.
It will be taken up tomorrow.
Obliged.
That means 12/9/2023. Okay.
Item 9.
My lord, under section 20B, 2C and 25 NDPS Act, sentence in 10 years, fine in 1 lakh, custody since 17/2/2014, custody more than 9 years.
କେବେଠୁ
17/2/2014, custody more than 9 years 3 months.
ଜମା ଯାଇନାହାନ୍ତି
ଏଣ୍ଟ୍ରି ମିଳି ଯାଇଥିଲା
ଆଉ କହୁଛନ୍ତି କଷ୍ଟଡିରେ ଥିଲେ ବୋଲି।
ରିସେଣ୍ଟଲି ଯାଇଥିଲେ ସରେଣ୍ଡର କରିଛି ରାଇଟ୍ ଟାଇମରେ। କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ପାଇଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଥିଲା।
ଟୋଟାଲ କେତେ ପିରିୟଡ ହଉଛି ମୋ କୁହନ୍ତୁ? 9 ବର୍ଷ ରହିଲେଣି, 9 ବର୍ଷ 2 ମାସ 11 ଦିନ, ସେଣ୍ଟେନ୍ସ ହଉଛି 10 ବର୍ଷ। ୟେସ୍ ମିଷ୍ଟର त्रिपाठी,
Yes, my lord.
ऐसे डिसीजन टा जो दी दिया UNDPS लो, are the Land Council for the petitioner and counsel for the state. The Land Council for the petitioner submitted that out of 10 years of substantive sentence, the petitioner has remained in custody for 9 years, 2 months, and he was released on bail, interim bail. ଆଗରୁ ଯାଇଥିଲେ interim bail?
ନାଇଁ my lord, 25/1/2023 to 25/4/2023.
He was granted interim bail by this court on 25/1/2023
to 25/4/2023. ସରେଣ୍ଡର କଲେ
25/1/2023. Okay. He was granted interim bail, and after he surrendered at right time. Land Council, and therefore, and since at this stage there is no chance of hearing of the appeal, the bail application may be favorably considered. Land Council for the state has produced the custody certificate of the petitioner from Superintendent Sub Jail Parala Khemundi, which is dated 28/7/2023, from which it reveals that as on that date, the petitioner has remained in custody for 9 years, 2 months, and 11 days. Custody certificate is taken on record. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, and period already undergone by the appellant, absence of any chance of early hearing, and keeping in view the ratio laid down by the Honorable Supreme Court in case of Mohammed Muslim alias Hussain versus Swanson, I am inclined to release the petitioner on bail. Yes, allowed.
Published.
For one of the IPC millets.
Copy of deposition not filed, madam.
There's noting to that effect, millets, that I have
What
filed the
noting?
copy. I have a receipt also showing copy of depositions filed.
Deposition copy received at Black Sea. मगे दियंतु ऑफिस रो मगे दियंतु काली नवा टेकअप करे काली एटा डाकि तो मोर हले 12 तारीख 12/9 Next.
Item 14.
May I please, my lords? This is a matter where the appellant has been convicted under Section 7. The sentencing portion is at page 48 of my lord's brief. We are giving a copy of the depositions to the court. To the Vigilance Council, we have already given much earlier. Now, in all, my lords, there are 10 witnesses here. PW 1, 2, 3, 4, these are all Caesar witnesses. The important witness here would be PW 5, the complainant, which is at page 6 of that compilation which we are giving today. He was declared hostile.
Who has declared hostile?
PW 5. The complainant was declared hostile.
Okay.
So if my lord would see that portion of that deposition.
Mr. Gautam Misral and Senior Advocate files the appearance memo which is taken on record. Yes.
Now,
PW 5 is the that decoy.
My lord.
Okay. He has not supported the prosecution case.
He has not supported. My lord may kindly see that page 6. Just one paragraph only.
Right, I've seen it. And what about the overhearing witness?
Overhearing witness would be PW 7, which is at page 12 of that compilation. Here the relevant portion would be at page 12 itself, towards the middle. The vigilance staff told me that R.I. Aska was demanding money for mutation of the person present in the room. The complainant disclosed that R.I. was demanding so-and-so for mutation, for which he filed the case.
No, that is super as Olga. We come to that.
Then next page, paragraph 2. As there was crowd in the office, I could not hear their discussion, but I saw
where? As there was crowd in the office, I could not hear the discussion, but I saw the complainant handed over the tainted money to the RI.
My lords.
Right hand count kale, I entered into another room used as kitchen. I gave the signal, vigilance staff entered, so on, so on. The accused inside the. So if voluntary acceptance is there,
my lord,
so it would presuppose that you have demanded the money and accepted.
My lord, that is something which I wanted to just clarify. If my lord would take up that constitution bench judgment,
yeah,
it says, if my lord would allow me to show paragraph 88 from that judgment. The conclusions regarding the difference of opinion, they would appear at paragraph 88. If I may slowly place that paragraph, paragraph 88 is at page 776 on the left hand side.
Yes, sir.
What emerges from the aforesaid discussion is summarized as under 88.1a. Proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the accused public servant under section 7 and 13(1)d so and so. Then my lord may kindly see 88.2b. In order to bring home the guilt of the accused, the prosecution has to first prove the demand of illegal gratification and the subsequent acceptance as a matter of fact. This fact in issue can be proved either by direct evidence, which can be in the nature of oral evidence or documentary evidence. 88.3c. Further, the fact in issue, namely proof of demand and acceptance of illegal gratification, can also be proved by circumstantial evidence in the absence of direct or oral and documentary evidence. 88.4d. In order to prove the fact in issue, namely the demand and the acceptance of illegal gratification by the public servant, the following accepts have to be borne in mind. Serial number I. If there is an offer to pay by the bribe giver, without there being any demand from the public servant, and the latter simply accepts the offer and receive the illegal gratification, it is a case of acceptance as per section 7 of the Act. In such a case, there need not be a prior demand by the public servant. Two, my lords, may not be relevant in this case, but I am placing it. On the other hand, if the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it is a case of obtainment. In the case of obtainment, the prior demand for illegal gratification emanates from the public servant. This is an offence under 13(1)(d)(1) and 2 of the Act. Serial number 3, my lords, is very important. In both cases of I and 2 above, Roman 2 above, the offer by the bribe giver and the demand by the public servant respectively have to be proved by the prosecution as a fact in issue. In other words, mere acceptance, my lord, this line, my lord, may kindly take. In other words, mere acceptance or receipt of an illegal gratification without anything more would not make it an offence under section 7 or section 13(1)(d), I and 2 respectively of the Act. Therefore, under section 7 of the Act, in order to bring home the offence, there must be an offer which emanates from the bribe giver, which is accepted by the public servant, which would make it an offence. Now, if my lord would further read into this, paragraph 15 on in the top, B. Jairaj has also been approved. The judgment in B. Jairaj, which was discussed here, that has not been held to be bad law. And B. Jairaj, this was the case. It was a case of just proof of acceptance and there was no proof of demand. That law has not been overturned here. So unless they prove demand, which my lords has also held in a series of judgments, unless demand is proved, then the other things may just collapse. Mere acceptance, here that line I just placed, my lords. In other words, mere acceptance or receipt of an illegal gratification without anything more would not make it an offence under section 7 or so and so respectively.
No, this is to be, if it is conjointly read with that Roman 1,
my lord,
because he there says that suppose in a case where there is no demand is proved,
my lord,
but it is proved that there is an offer,
my lord,
so of the bribe giver, and there is no demand, so let us say, and the latter simply accepts the offer.
My lord.
Here, what the overhearing witness has stated, that I saw that this man
acceptance is there.
Okay. So once acceptance is there, and that means he is offering and you are accepting.
My lord.
So in that way, the it would be a case of acceptance under section 7 of the Act.
My lord.
So far as 13(1)(d)(1) and 2, it's a different matter. But for 7, what it says that once this much of evidence comes, let us say the decoy also didn't say anything, but other evidence.
If I may be allowed, my lord.
Yes.
This 1 has to be read along with 3.
Right.
3 says, in both cases of I1 or whatever, small I and 2 above. So we are concerned with I. So in a case of I, the offer by the bribe giver and the demand by the public servant have to be proved. So have to be proved by the prosecution as a fact in issue. Next line, my lord, is very important. In other words, mere acceptance or receipt of an illegal gratification without anything more would not make it an offence under section 7 or section so and so.
No, acceptance, simple acceptance is different, but offer and acceptance, that is another thing. Acceptance,
my lord.
This what it's Roman 1 says about the offer and acceptance, both the things are to be there. Then even if the demand is not there, 7 will be attracted. But what it says that suppose somebody has accepted it, but there is nothing that there was any kind of offer to him. He has accepted maybe from some other source, but from that particular person, suppose this evidence is lacking, then you can get one example. In this case, what has happened? In this case, if we read the evidence of the that
PW5.
PW5, no, that overhearing witness.
That's
That is
PW7.
PW7, right? So PW7 ର version ଯଦି ଆମେ ଦେଖିବା ତାହେଲେ ଏଇଟା 1 ଭିତରକୁ ଆସିବନି କି ପ୍ରଥମ ରୋମାନ 1 ଭିତରକୁ ଆସିବ କି ନାଇଁ କଣ? If there was an offer, he tendered the money, bribe money, or whatever it may be, and the person accepted it, counted it in the right hand, and then he went to keep it there. So that they say that it's a case of acceptance under section 7. But what they try to distinguish it that suppose he has accepted it and there is no offer. So there is a thin line of distinction between the two.
Had they overruled, if my lord would just see paragraph 15 of this judgment, the judgment in Jairaj, they have in fact concluded that there is absolutely no conflict in the earlier view. Paragraph 14 and 15 at page 752. I bow down to what falls to my lordship. If we read I in isolation, then the scenario may be different. But then I has to be also read with 88(1)(a), which says that proof of demand and acceptance is sine qua non. So,
because even if somebody doesn't offer, also somebody can accept it through other sources also. He can. That means so. These are two different stages. So here, what has come, it may not be under that 13, but 7. How do you overcome it? 7, if this evidence is there.
then the other principles which have been laid down here regarding the evidentiary value of a hostile witness. Here, the main person who triggered this entire thing, he has completely not supported the prosecution case.
And I think in this particular case also, that hostile part, that is there in
That is there, my lord. That would be
886.
The relevant paragraphs regarding hostile.
That is 88.6.
No, 86 and 87 may be seen.
No, you come to 88.6, the next page, 777.
My lord.
In the event the complainant turned hostile,
my lord, or has died or is unable to let in his evidence during trial, demand of illegal gratification can be proved by letting in evidence of any other witness who can again let in evidence either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. The trial does not abate nor does it result in an order of acquittal of the accused public servant. This is there, but this has to be...
ଦାବିଟା କଣ ଏତିକି ଟଙ୍କା ଦେଲେ ମୁଁ ତମ କାମଟା କରେଇବି, ନହେଲେ କରିବିନି. So that becomes the demand. Then comes ସିଏ ସେଠୁ ତାପରେ ସିଏ ରାଜି ହେଲା ଆଣିକିନି, ବା ରାଜି ଯାହା ହଉ by forcefully ସିଏ ଆଣିକିନି ଟଙ୍କା ଦେଲା and tendered the money, it was accepted, and then recovery comes. तो suppose demand रहिला नाही गोटे केस रे, demand रे evidence टा because ये रहीगला मरीगला बा ये hostile ହେଇगला, से आरो witness टा जो overhearing witness टा हेटा दूरे रे रहीगला, तेणु सीए सुनी पारलानी conversation आको भीतर कौन होउची. But simply he says that one person offered the money to the accused accepted it. So So that means some kind of talk between them and then voluntarily accepted. एठी से कहउचंती ए सिचुएशन रे जे हेई न पारे जे डिमांड न होई कि पारे सिए तो हुए तो निजे कहि थाई पारे जे आपण एटा रखन मो कामटा कर देबे.
And my lord, then my lord has to also see, probably subject to the court accepting it, 88(1)(a), where they are not making any distinction between section 7 and 13(1)(d). 88(1)(a) at page 776. They say that proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is a sine qua non in order to so and so under 7 and 13(1).
No, ସେଇଟା ଗୋଟେ generally କହିଦେଲେ ତାପରେ ସେ କହିଲେ ଯେ exception ରେ ଏଗୁଡାକ ମଧ୍ୟ ହେଲେ ମଧ୍ୟ ପ୍ରମାଣ ହେଇ ପାରିବ. ଆପଣ ଆଉ କଣ ବାହାର କରୁଛନ୍ତି ସେ ଜେରାରୁ ଆଉ କିଛି ବାହାର କରୁଛନ୍ତି ସେ ଓଭରଇନିଂ ୱିଟନେସ ରୁ? ଗୋଟେ ତ କହିଲା ଦେଖି ପାରିଲାନି ତ ଏମାନେ କଣ ହେଲା ମୁଁ ଶୁଣି ପାରିଲିନି ଯୋଉଟା ପ୍ଲେସ୍ କରୁଥିଲେ ସେଟା ପିଡବ୍ଲ୍ୟୁ କେତେ ସେ ସାକ୍ଷୀଟା?
ସେଟା page number 13.
13.
As ସେଟା ତ
recovery କୋଉଠି ହେଲା? Hand was torn, change color.
Hand was change color. There is no problem.
Okay. Recovery कोठी छि?
Now, so go take one para, if I can show my lords, para 5 at page 14.
1-4.
I am cited as a witness in another so and so, no written so and so. Again says one relief order was issued to me. The complainant did not disclose before us when the demand was made and where to be paid. He also not disclosed before us when the bribe will be paid.
What is your reply to that particular question that he offered you and you accepted it?
That in 313.
Yes.
313, our plea was that
total denial or anything that
no,
it
there
was for this
there
purpose.
was an explanation that my lords.
What is that accused statement? Accused statement
that incidentally, what the noting in the list says that the TCR is not received. I'm not sure whether it has come. List noting says that TCR not received. The noting in the list says that there is no TCR.
Then let it come because I want to see that particular answer to that.
I bow down to that. In fact, that if the TCR comes, we also take it in a pen drive. It will be easier for us. My lord may allow us to also take it.
Right. So, Mr. Misra, next week there are 2 holidays. Better let us keep it on 25th.
My lord. But I just wanted to draw my lord's attention to 2 more paragraphs of that judgment.
Yeah.
P. Jairaj, which has been approved. Because similar matters would come up. Also, I have other matters which are coming up.
No, give those. We can hear it.
But Jairaj, para 14 and 15 of this judgment may be also important. That view has not been overruled. And the fact situation in Jairaj and this case.
Mr. Misram, suppose this particular evidence is there that he tendered the money, you accepted. Then to corroborate it, the hand wash is there and the recovery of money from your possession was there. So now if a question is put to you that from such and such evidence, it appears that he tendered you the money and you accepted it. Suppose this much is asked, but what answer you have given? Either you may say that no, yes, I have given money, but it was not for this bribe amount, it is for this purpose. He had some work for some fees is to be paid, whatever it may be. So just that question answer becomes very material. So Number two, whether any work was pending with the accused at that point of time or not to make a demand. Is there any evidence that what work was pending with him? And that also you examine.
So let the TCR come.
Like the London Council for the, it appears that the trial court record has not been received. The reminder, it must have been called for at the time of admission. Where is the order sheet?
Order dated 8/5/2020.
Order admit, call for the, yes, it was been called for. It appears that on 8/5/2023, while admitting the appeal, trial court record has been called for. Let reminder be sent by the Register Judicial to the consent court to send the trial court record immediately. Place this matter on 25th of September 2023. If the trial court record reaches, in the meantime, the copy of the same shall be given to Mr. Misra. In pen drive for them, pen drive. Okay. Yes.
Presence my kindly.
Yeah.
I am present.
Mr. Das is present.
And also that copy, one copy may be given.
No, he wants to take the entire LCR copy by way of
No,
pen.
no, I do not want the LCR copy. I have got the copy of.
Right. He filed the some deposition copies and citations with a memo which had taken on record. Upper lekhithili mu je appearance memo file. Baki this we just add it. Yes, it will come on 25th.
We are all great.
Item 15.
My opinion, I beg apology, my lord, because just few minutes ago I saw the copy of the opinion memo to the State Council, my lord.
There are two defects pointed out. One is 5D means that copy.
I have already supplied.
And what about 5E? 5E is court fee of ₹12 not paid. And
in course of day, I will, my lord.
Seal of jail authority not furnished. Seal of jail authority means wakalatnama. ଦସ୍ତଟା କୋଉଠି କରିକି ଆଇଲେ ଯୋଉ ଟିପ ଚିହ୍ନଟା ଏଟା ସିଏ ତ କଷ୍ଟଡିରେ ଅଛି ନା
କଷ୍ଟଡି
ଏଇ ଯେତେବେଳେ ଆସିଥିଲା କୋର୍ଟକୁ ତାକୁ ନେଇଯାଇଛନ୍ତି କି
that was supplied by the advocate for the court below, my lord.
ଆରେ କଷ୍ଟଡିରେ ଯଦି ଥିଲା ସେ ଆଣିଥିଲେ ତାର ସିଲଟା ନଥାନ୍ତା ଜେଲ ଯୋଉ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଖାଲି ଆପଣଙ୍କର ଟିପଟା ଅଛି ନା ଆଉ ସେଟା କୋର୍ଟ ବାହାରୁ ଯେତେବେଳେ ଆସିଥିବ କୋର୍ଟ ବାରାଣ୍ଡାରୁ ନେଇଯାଇଥିବେ ତାମାନେ
I will file another.
File another wakalat. The Land Council for the appellant submits that he has already served the copy of the appeal memo along with the impugned judgment and interim application copy guda deyichanti apanku.
Yes, ma'am.
And copies of interim application to the Land and State Council. So far as defect number 5 is concerned, you will remove the same within
2 weeks.
Okay, within 2 weeks. So dita jinsh apun kariya padibo se wakalatnama fresh wakalatnama anibe ଆଉ se jo ଟଙ୍କା କଣ ସେ 12 ଟଙ୍କାର ଏଟା ଦେଇଦେବେ. Okay, list this matter, then let it come on 25th September. Okay, 25th September. Yes.